Hello, everyone. Peter Isikoff here. Just confirming y'all can hear me.
Yeah, you're light. You sound like you're at a distance, but your video is also sideways.
Is that still not coming up the right
Yeah,
way?
you're still sideways. Now you're upside down. There you go. Awesome. So, Chairman Isikoff, I show it's 1:31. The meeting is being recorded, and I show the following commissioners present: Chairman Isikoff, Vice Chair Brown, Commissioner Biggerstaff, Commissioner Furman, Commissioner Waddell, Commissioner Scott. I don't see Commissioner Young, and we've not received an email from him. Maybe he'll join us shortly. And also, I had forwarded an email that Commissioner Singleton is unavailable for a prior training commitment as an alternative or as an alternate. Thank y'all for being with us. I did send a memo in the reminder earlier. I hope everybody had a chance to get it. Apologize for getting that to you late. It was hot off the press. But that just kind of gives y'all some updates from the July meeting, just to let you know what staff has been working on on the request that the commission had made and on the presentation that the commission heard at the last meeting. So Chairman Isikoff, I'll turn it over to you.
Thank you. Welcome, everyone. This is the September meeting of the Greensboro Minimum Housing Standards Commission. We are hearing cases involving code violations that city inspectors have found at the properties. When your case is called, if you can raise your hand online so that our moderator can let you in. And then we're going to do our best not to speak over or interrupt each other, just so, especially with video internet recording, that it can be better heard.
Chairman Isikoff, if I can just stop you for just a second. The second court reporter is not on the call.
Okay, so we would need to wait for her to get on.
Yeah, let me get her on. She's messaging me. She's having trouble getting in.
Okay, thank you.
The call is recorded, so we can still have the minutes of the quorum, but I'd rather have the court reporter present.
Sure.
The Chairman Isikoff, just from earlier, I do see all commissioners present. Commissioner Young has joined us.
Wonderful.
And again, I just messaged the court reporter, so if we could just be at ease until the court reporter signs on.
Yeah, and for everyone that's online, we'll be at ease. What that means is keep the audio on so you know when we come back, but we're just gonna pause our hearing right now till the reporter gets here. So we'll be at ease until further notice. I guess I should possibly do a second for that. Is there anyone on the commission?
You can just put it at ease, Mr. Chair. It don't require motion.
Sounds good. And we are put at ease. Everyone take care and just be listening for when we come back.
Hey, Judy, can you hear me?
Yes, I've got you.
Okay, awesome. So the meeting was called to order. All the commissioners are present, with the exception of alternate Commissioner Singleton, which gave notice that she would be at a training prior commitment. That notice has been given to the chair already. The chair put the meeting at ease, waiting for the court reporter. So Chairman Osikoff, back to you. We have a court reporter present.
Thank you. So proceeding with our docket, the first thing on our agenda is if anyone on the commission has a motion related to last month's minutes, those were dispersed to commissioners prior to this meeting.
I have a comment or a change rather.
Um, Please go.
In the minutes, oh gosh, it's gonna be hard. Under quarterly commission updates. It's after that, I think it's after that. Actually, might be in other business. There are no page numbers, so I'm having a hard time making sure of where this is.
Well, we're happy to address it if
Okay,
some-
I think it's under other business. There's a whole discussion that's missing from the minutes. And something, and please correct me if I'm wrong, but I thought that we had brought this specific item into our other request to go to city council. But it says that Ms. Furman asked staff to provide a list of inspection fees that were issued from March 2020 to December 2020. I actually had requested that through the public records portal and had received an email. And so I think the record should say Ms. Furman had received a list of inspection fees that were issued from March 2020 to December 2022 or 2020, sorry, through public records request and asking for clarification and on the wording of the response. And then additionally requested or had asked for us to vote to ask council to forgive the $6,000 plus in inspection fees that were amassed during that time. None of that is in there. So
Thank
We
you.
did.
And I appreciate you bringing that up. That might merit a longer discussion at the end of the meeting so we can get folks out of here.
sure.
Commissioners, what are your thoughts on that? That we just postpone the approval of last month's minutes till the end of the agenda?
I'm okay with that. Yeah, I didn't know what was going on with the minutes from last month. So yeah, I think at the end of the agenda will be fine.
Okay, so let's take that.
Mr. Chairman, I threw in a correction I'd like to see. I put it into the chat for the sake of expediency, and I'd be happy to wait until the end of this meeting in order to talk about it.
Okay, thank you. So we'll put that under the same discussion item as Tracy's. Are there any other changes, deletions, or additions to the agenda today?
Yes, sir. Number On the revised agenda, which is now item number 6, 1010 Lexington Avenue, that appeal has been withdrawn by the appellant. And
We'll remove that one.
number 10, 2105 Maywood Street, we do not have consent for a virtual meeting from that property owner.
We'll remove that one as well. And I want to make sure I do not have an amended docket. Everything I'm looking at was numbered a little differently. Just want to make sure I have the latest and greatest.
It was the one that was emailed yesterday, I believe.
All right, I do have that here. Yes, the one sent. Yep. All right. So seeing that items number 10 and number 6 are removed from the docket, we will proceed with item number 7, 820 Roberson Comer Road.
I do see that Ms. Council is present.
Oh, wonderful. And we should probably go ahead and before we get started, get staff sworn in, and then we'll go one by one through the cases with the folks that are here.
Troy, if I could, did we want to do the public comment period before we begin the cases, or are we doing that afterwards?
There is, it's a public comment period that would follow now. It would be before the first case is called.
So let's go ahead and get everyone sworn in, all staff, and then we'll go to the public comment period.
Okay, would each of you raise your right hand? Do you swear or affirm that the testimony you give in the following matters will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you. Please proceed.
Thank you. So everyone, this is a relatively new thing that we're trying, having a public comment period before we hear any specific cases. So if anyone has anything to say about the process of the condemnation, what inspectors do, anything about what the commission does, you're free to speak. The only thing we won't do is address specific cases during this time. So if there are any members from the public that wish to speak about general public comments or concerns, now is the time.
Mr. Chairman, just as a point of clarification, in past meetings, we usually have you or Vice Chair Brown asking if there are any additions to the agenda. I don't want to interrupt your thing, but I wanted to make sure that an agenda item was added at the end of this period or at the end of the entire discussion.
And I apologize.
Some issues I brought up.
But then I moved on. So yes, sir. What would you like to add to the agenda?
I don't know which number it would be, but normally we would tack on these items at the end of our meetings or at the end of the regular business. This was in regards to the Agapian case and the role of the commission.
All right, so that's noted as discussion item, the Agapian properties and the role of the Housing Commission.
Thank you.
Thank you. Before we proceed with public comments, are there any other additions that we missed or deletions or changes? All right, seeing none, we'll return to the public comment period. If there's any members of the public that wish to speak to Housing Commission standards generally, ask questions, anything as long as it doesn't relate to a particular property, the floor is open to the public. And Troy, I'm guessing there's no one raising their hands or anything like that on the Zoom app.
No, I don't see anything. There is a statement that that generally, just since this is new and we're waiting to see if anybody has anything to say, there is a statement that we did put on the revised agenda. We had it on the in-person agenda, so it's just kind of different for us to switch it over. We're going to also put on next month's agenda how a person can register to speak for public comment. And we're following the same guideline as City Council, 3 minutes per person, and then a 10-second warning prior to the mic being shut off for any person that wishes to speak. One of the things also during the public comment period after speaking with City Attorney's Office is the public comment period is not necessarily a Q&A, to where the person is asking questions and the commission's answering. It's a forum in which the commission is listening. But what we've done is on that revised agenda, you'll notice that we placed an extra item at the end of the agenda, which is item number 19 that says commissioner discussion and reflection, so that the commissioners would have a chance to respond publicly to anything that they had heard either during public comment, during the cases, that doesn't necessarily would affect the outcome or the biases of any case.
And I think that's a great idea. So that kind of falls in line with our general discussions of housing commission policy at the ends of meetings. That all sounds great. Seeing no other public commentators, we're going to move into the docket. Our first one is 820 Roberson Comer Road. That's docket item 7.
So, Mr. Chair, if we could get the two things completed. One, ask the court reporter to swear in the witness, Ms. Counsel, and then get permission for the hearing from Mr. Baker.
Yes, sir. And is Ms. Counsel available? Is she?
Yes.
Yes.
Hi, Ms. Counsel. Would you raise your right hand? Do you affirm the testimony you give in the following matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please proceed.
Thank you. If I also have another interested party that is privy to the situation, does he need to be sworn in as well at this time?
If he's
Yes.
going to give factual testimony, yes, please.
Please state your name for the record.
Ray Hux.
Please raise your right hand. Do you affirm the testimony you give in the following matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please proceed.
Ms. Counsel, my name is Tony Baker. I'm Assistant City Attorney. State law requires that we obtain your consent to participate in this hearing virtually. So I have a brief script I'm going to read to you, and then I'm going to ask for your consent. The Minimum Standards Housing Commission requires your consent to proceed with this hearing since the commission is appearing remotely. If you choose to wait until the commission meets in person, the case will be postponed until that time. During this delay, the commission will not make any findings regarding the property or issue any orders against you. Once the commission is able to meet in person, the commission may proceed with your case, even if you aren't able to appear in person at that time, or if you're only able to appear remotely. If your case is delayed until the commission meets in person, any pending penalties or reinspection fees for monthly safety inspections will continue to be assessed. Your property is already in compliance because you're appealing a penalty reduction, so that's not going to apply to you. But with that said, do you consent to the virtual hearing?
Yes.
Thank you, ma'am.
Thank you, ma'am. Ms. Counsel, just tell us what's going on with this property.
Yes. Thank you for your consideration in hearing my appeal. So the situation that we're dealing with is I am filing an appeal here to eliminate the remaining $500 showing owed from the civil penalty. What I want to reiterate is that the lack of clear communication and adequate correspondence has led to fees that could have been rectified. Just the situation started on January 9th, 2020. Jared LaRue was informed that I would not be able to attend the hearing. He emailed me to let me know that the hearing was upheld and 90 days would be granted to have issues resolved. He stated that if I kept him updated, that no further action would be taken by the city of Greensboro. My understanding was that this meant that as long as I kept him updated, no fees or penalties would be assessed. Talking to him on February 23rd, 2021, he made it clear for the first time that there were two different types of orders and that fees never stopped being assessed. I have been updating Jared from the start, thinking everything is okay until I received this bill for the first time in February 2021. This issue could have been further rectified if I had received a bill the first month the charges accrued, and I would have called the office to get further clarification. I know from talking to Tony in the office that this is in place now, but it seems unfair to have to pay a penalty of any amount due to the department not having an adequate system in place previously. The only way I knew of any fees was upon receiving a letter from collections, of which I responded immediately. And for the demolishing of the house, the removal of the asbestos, I've already spent almost $7,000. So even, having to pay a $500 fee is just extraneous at this point.
Thank you, ma'am. And sir, did you have anything you wanted to add?
Yeah, just wanted to say that fee was, I believe the timeline, Jeanette, you may have the timeline, but I believe that fee was notified like a year later, that fee was owed. At no point in the beginning was it told to us that a fee was due, or what was going to be due. That was something after the fact, after we had complied with everything and spent this money to demolish the property.
Thank you. Commissioners, I'll open this up for discussion. So this is a civil penalty reduction matter. We're looking at the last 500, the decision regarding that. So I'll open it up for discussion.
Hey, Mr. Chairman, this is Andrew here asking this question. I'm a little confused, like, can someone help me out, or maybe you can help me out about this memo that I think Troy sent on to us just today, just a few minutes ago. It seems to say that the city's position is you cannot reduce, we cannot reduce anything below 500. Am I reading that right, or am I confused here?
So my understanding, and I'll defer to staff and staff counsel, is that as a policy, staff does not have the ability to reduce below 500, but that if it's appealed to the commission, we as a commission could do that in our discretion.
If I could correct you, that's incorrect as far as your discretion. Your discretion is limited to the discretion of the compliance officer who is bound by the policy. That's by city charter. The council does not have the authority to amend that. That would have to be amended by the state legislature.
The $500 limitation?
No, the council's authority is limited in this case to stand in the shoes of the compliance officer. You can do whatever the compliance officer could do. The compliance officer is subject to the penalty reduction policy. And that policy is that penalties will be reduced for amounts spent to rehab the home, but no less than $500 if they, of course, exceed $500. So you are limited by that policy.
Understood.
This is Tracy. Who creates the policy? Mr. Baker?
Staff creates that policy. It's been reviewed by staff, by the city manager's office. The ordinance delegates to staff to the neighborhood development director the authority to establish that policy. It was reviewed just recently with Ms. Blue, the interim director, and with the city manager's office. And this is the final version of that policy.
But if we were to reverse the inspector, there would be no fines. Is that correct?
You don't have the authority at this point to reverse the inspector. That issue is long gone. The inspector had a hearing, that order was upheld. It was not appealed, and the appeal of that inspector's order is not before you. The only thing before you is the appeal of the civil penalty reduction policy.
So I guess I'm confused as to what we're considering today, because all they're looking to do is have their $500 reduced. And you're saying that we don't have the authority to do that. So I guess my question is, why would this type of case be before us right now if there's no decision for us to make?
Well, your authority in this case is to determine whether the civil penalty reduction policy was correctly applied. Were they in fact given full credit for all of the work that they have done, and has the amount being assessed, does that accurately follow the civil penalty reduction policy?
Mr. Attorney, we don't see the receipts or anything like that. So how are
I'm
we
sorry?
supposed to know whether the city has properly carried out whatever costs above and beyond that $500? I don't understand what you're saying.
Yeah, so staff at the very beginning has the burden of proof to present its evidence. Staff has not been asked to present evidence yet.
Like what I don't get, Mr. Chairman and Mr. Co-Chair, is like you said, Peter, what are we doing here? Like, is Mr. Hoax and Ms. Counsel contesting whether they've gotten their proper reduction down to 500? Because what I'm hearing is they're asking for the 500 to be reduced to 0.
Well, I have a question, if I could interject.
Yes, sir.
The question is the assessment of the $500 to begin with. When we received a letter stating that they were going to meet to decide whether to demolish the property, we were informed that as long as you comply and as long as you inform us of what's going on, there will be no penalties. The next time we heard from him, what was the guy's name? Jared? What did you say the guy's name was?
It was Jared LaRue. The next time that I even knew of any type of bill was when I received something from collections a whole year
later. Yeah.
So
So my question is, hold on, Jeanette. So my question is, why was the $500 fee? Why were we assessed any penalty, period, when they looked at the property, they met on the property, they said the property had to be demolished, and then we did that. It was a delay for COVID or whatever, but we had the property demolished by what was it, June or something like that, after the COVID delay. But other than that, we did the asbestos testing and all that, and had the stuff done. We complied, so we were blown by any type of penalty. There was at no time where we informed that there was going to be a penalty for having to demolish the property. So that's what it's not, you guys are arguing about whether it can be reduced less than 500. We're trying to figure out how we ever assessed a $500 penalty. We were never told that existed, that we were going to be assessed that. Am I correct in that, Jeanette?
Mm-hmm. So, and to clarify, I understand that the total amount of civil penalties was originally $1,560, that you had a portion of that waived based on your invoices down to the $500 minimum. Is that correct?
Yes, now that is correct.
Okay.
And even with that, like, I guess what we keep saying is that if we even knew from the beginning that these penalties were being accrued or they were being assessed, there, we would have tried to, rectify it as soon as we could, but we had no correspondence whatsoever to this, to this point.
Like,
So
why was the
why are
penalty
we being
assessed is
penalized?
the question, like, that nobody has ever answered. Why
When
were
was
we penalized?
when was the first time you received notice from the city that they were collecting on this penalty amount?
February of 2021, when we received the collection notice. And then that's what I said before that, that when I talked to Tony in that office, there was not a system that, there may have been one, but it wasn't effective. So there were no notifications being sent out. And they just started that. So then that's when we started to, that's when I received it in February. And I immediately called collections because I thought that I didn't know that there was anything, any type of fees being assessed. I know that the property had been demolished and I thought we were done with everything. So that's why I was floored when I received any type of fee.
Yeah, the guy said that we would be fine, that as long as we kept him abreast of what was going on, we didn't know that we would be assessed anything. And then the next time we talked to him, which is, after everything was done, next time we talked to him, he said, well, it's two different entities. Then this is going on in the background where you're dealing with me as far as what you need to do. So he knew the whole time and never said anything about it. So that's what this whole thing is about. It's not whether we should go ahead.
And I updated him monthly, just say, okay, we're doing this part with the house, the people with the asbestos is coming in with the house, and he responded, okay, I'll mark that down. But at no time did we know that still that fees were continuing to be assessed.
Mm-hmm.
Did y'all ever get a notice of civil penalty code compliance on December 12th of 2019? Basically explained to you that you've been assessed a civil penalty of $200 for the first day of the expiration of the order to repair, and then you get charged $10 a day till you get it right, till it's either gone or fixed. Did y'all ever receive that?
There was a notice that was received, but again, with talking to Jared, and he was telling us that as long as we kept him updated, then no further fees would be assessed. So with that understanding, we were thinking that nothing else was going on because I'm keeping him updated monthly of what's going on.
Right, because they had to meet first and decide on whether the property should be fixed or if the property had to be condemned. So they had to do that. The letter that you're talking about was December 2019, and then they had the meeting in January, right? January 2020 to make a decision on it. Or February.
The reason why I'm asking about this letter is because obviously we got paperwork in front of us, and that letter basically was a letter of condemnation, which basically at the instance of condemnation, just so you know, you're instantly charged $200. Can't nobody live in there. Ain't nobody supposed to go in there. That's what that was. So that's what that letter was. That was an instant fee right there. Then every day afterwards, till it's brought into compliance, it's $10 per day. That's why I'm asking you. So what you talking about is when you first get your very first letter, which is, hey, there's a problem. We need to talk about it. At this point, at the letter I'm talking to you about, by the time you get a $200 fine, it's already gone past the 30 to 60 to 90 days or whatever whatever you've worked out. It's already gone past that. Now you've got that yellow piece of paper on the door that says condemned on it. That's when your money starts. And from what I'm understanding here is that
we didn't have a condemned letter in December because they didn't meet until 2020. So how was that going to start if they hadn't met on the property yet?
So y'all never met. Okay.
How did they meet at the courthouse for a meeting in December? That didn't happen in December. So how did the fine start in December?
Because just so you know, our paperwork is showing that there was a letter sent in December of 2019 stating that it was a posted condemnation has been put on the door, blah, blah, blah. And that would have began your civil penalty accruance. That's where it starts.
my-
Start at $200.
So my question to you, hold on, Jeanette.
Hold on a second.
Hold on one second. So my question, hold on, let me ask him something. So why did they meet in January if it was already condemned?
I don't know yet. I'm about to ask the inspector that in just a second. So hold on.
Okay.
Inspector Rulu, you apparently met in January. What was that second meeting about and what was discussed?
It was January 9th of 2020. There was a hearing.
Got you.
So
Inspector
what
LaRue,
you're talking about there is on January 9th of 2020.
all right. Got you.
So that is when the order was upheld.
You cut in and out.
Yeah, Jared, we can't quite, your connection is kind of wavering.
Yeah.
Mr. Chairman,
Yes, sir.
if I may, in a decision case like this, when the decision is appealed, just as we would do in any other case, staff has the burden of proof to present the evidence for the for the commission to consider, and then the appellate gets the right to question or to present their own evidence that would be to the contrary. Would you like us to present that evidence at this time of what was submitted to us in order for the commission to make a decision as to whether or not the compliance officer followed the policy?
Sure, and I think that gets to what Quentin was proposing of we need to, from you. Yeah, feel free to present whatever evidence you have.
Okay, so in a reduction decision, the city ordinance authorizes the neighborhood development director to make a reduction of the civil penalty reduction policy, which is on your screen. This policy was revised on September the 2nd by interim director Cynthia Blue. This reduction policy letter would be submitted and provided to you as evidence of its decision on this basis. The only difference between this policy and the policy in place at the time we considered a reduction is number 4 and number 5 on this policy was not in place. Now, the civil penalty reduction form that was submitted by appellate counsel was submitted on February the 23rd, 2021, and it is in regard to case number 16-008135 for the property of 820 Roberson Comer Road. The property owner is Jeanette Counsel. Our records indicate that Ms. Counsel has received all evidence, all letters from the beginning of this case to current, including all notice of violations, notice of hearing, civil penalty notice, the condemnation notice, as well as the bill for the collection of the civil penalty from the collections division of the city. The total amount of civil penalties assessed that was reported to us from collections is $1,700, or actually from what Ms. Counsel had submitted was $1,710, with the total amount of invoices attached to $7,175. And Ms. Counsel is the requester. Staff reviewed this request and found that the civil penalties due to the city was in the amount of $1,560. The date the civil penalty began, which is issuance by the Inspector LaRue, is December 12 of 2019. Those penalties ran at the rate of $200 the first day and $10 each day thereafter. That was sent through this notice. This is your case number that I just called, 16-8135. It was written to Jeanette L. Counsel, in which staff confirmed service, which is Ms. Holt. It was issued on December 12th of 2019, and it gives notice that a civil penalty that you are now charged the following civil penalty of $200 effective the first day after the expiration of the order to repair, plus $10 per day thereafter until the property complies with the minimum housing code. And it lets them know that they were December 12, 2019.
Thank you.
So staff determined that the issuance of December 12, 2019 is when the penalty began at $200 for the first day, $10 every day thereafter. The property was brought into compliance with confirmation of the inspector on August the 26th, 2020. Eligible amount of invoices for reduction is listed as $1,500 plus. It's written in our form. It doesn't mean that we didn't consider the $7,175. It just simply meant that our reduction policy, we have to look and verify whether or not there is a reduction in the amount of those fees that are assessed. A civil penalty due after reduction is no less than $500. So we placed $500 because we did confirm that with all the receipts submitted, that the penalties did go above $500, which is a requirement of the policy. And we also found that the receipts submitted were valid. Therefore, we gave the max reduction down to $500. This is a document submitted by Ms. Counsel. I believe that's what she just read to you earlier into the record. This was sent to us for consideration in a fee reduction. And you should have this in your packet too, commissioners. The first invoice provided is this is a demo contract of Abate Master, and it showed asbestos abatement and a proposal of $2,985. That definitely surpassed the $1,510 assessed. We also considered EME Industrial Services, which shows that an invoice paid for $4,325 also surpasses the $1,510, and an additional receipt of $610 for loads of dirt, brush, and a bobcat service that we do recognize correlates with a demolition process. So we did consider that and approve that as part of as consideration for the reduction. She did include all the violations are included because any penalty reduction must be a penalty that addresses or corrects a violation cited by the inspector. I did find in this review that all penalties that were submitted are eligible for reduction. However, that reduction, the civil penalty was only assessed at $1,560. So we made a full reduction and gave the credit of $1,060 because the policy and the city ordinance does not allow me as the designee of the neighborhood development director to go less than $500. So Ms. Counsel was given full reduction. I'll be glad to answer any questions.
Was there a meeting in January where they discussed these issues? Because it seems and appears that they have not had their atypical meeting, I guess, when the first violations first occurred. Was there a meeting? I guess, so basically what I'm asking is, was it condemned before they were given their due process to have their meeting?
Yeah, so with this being a 2016 case, the due process has laid out through the course of the enforcement action. Now, Inspector LaRue, I'll ask him in a second to explain that. However, until the inspectors gain compliance, the inspectors do meet with the property owners and the contractors throughout the enforcement process. And that can definitely be after the issuance of the order to repair. It can be after the issuance of the condemnation notice. It can be after the issuance of the civil penalty, because the ultimate goal is to gain compliance. So if there was questions that Ms. Counsel, I'm not sure if Mr. LaRue met with Mr. Huck, but if there were questions from the person about what to do, can I do this, or give an update, there definitely could be subsequent meetings afterwards. But Mr. LaRue, can you answer?
Yeah, so specific to your question, Councilor Brown, the meeting in January was for the Housing Commission. This would take place after the condemnation notice and civil penalties were issued in December of 2019. The Housing Commission meeting taking place in January of 2020.
But there was a meeting though. There was a meeting though prior to January, correct? Or there was not?
a meeting as far as the housing commission or a meeting
No,
with
the initial
myself
meeting-
and the owners?
Yeah, there usually is like a meeting of appeal, or usually when someone gets a letter that says, hey, you know, your house is, there's an issue with the property. These are the violations we found. Would you like to meet about them first? This goes
Understood.
before any civil penalty is assessed,
Yeah.
or any
So-
condemnation letter.
Yep, so the original hearing and repair order were sent out by Inspector Stovall in 2016. And those did have to be published in order to get good service. After
Did
that,
y'all publish them? Did y'all publish them and get good service?
yeah, the good service would be through the publication.
Okay.
And then following that, there was an extended period of a couple of years where the property was granted basically carte blanche until the time because they were participating in the rehab program.
Gotcha.
However, when the property got transferred over to myself in December, I spoke with our representative, Regina Womble Miller. And at that time, the property was no longer participating in the rehab program. Inspected the property from the exterior. There are no signs of any repairs being made at that point, and proceeded with the issuance of the condemnation and the civil penalties.
Were the people, I guess this now goes to Miss Counsel. Miss Counsel, were you ever made aware that it had not been accepted into the rehab program? Is there any paperwork that the rehab program or the city can show that it was not accepted? That's a no?
And Mr. LaRue, could you speak to your communications with the homeowners regarding the civil penalties, you know, the process of how that works, the $500, all that?
So, I mean, I can only speak to from the time that I took over the case in December. I understand that there was some confusion on the part of Ms. Counsel and any others involved with the property about when fees would accrue, when they would stop accruing, and things to that effect. And I've tried to explain that to them on multiple occasions, that these civil penalties would not stop. Now, in Ms. Counsel's earlier comment, she mentioned getting me updates after the property had already been upheld by the Housing Commission, and us not moving forward as long as they're showing progress. That is us not moving forward with the demolition of the structure, not anything to do with any of the fines or penalties at that time. If the owner is staying in touch with us and moving forward with a potential repair or demolition, and they can show us documentation to that effect, we would, of course, stay our own repair or demolition of the structure and allow them to do so, as opposed to just stepping on their feet, doing it at their own expense, and then trying to bill them for it.
Right, and at this point, Jared, this is the first time that you've made this clear to me as far as the fees, you know, 2 separate fees. And I think that's just one of the breakdowns of communication that I had. Because again, if I would have known that fees were still being assessed, then, you know, we may have tried to do something sooner at that point, but we did not know. And like, and as well, not dealing with you, but if someone is accruing fees, when do you decide to send them a bill from collections? I know that has nothing to do with you, Jared, but that's just a question that I have. Do you wait until the property is finished and then months down the road send us something from collections? Or is that something that you should have sent from the very first time that fees were being assessed? How should that work?
So I'll speak to our process specifically. I can't speak to collections process as to when they send out notifications, but essentially you're notified that there is the potential for civil penalties and reinspection fees at the issuance of the repair order. It's mentioned in the condemnation notice as well as the civil penalty notice itself. I would defer to someone else if they care to speak to collections procedure as to them sending notice out about collecting on those fines and fees.
So I can speak to the collections division. Once the administrative staff receives the assessment or the notice of civil penalty from the inspector, the administrative staff reports that assessment to the collections division monthly. Our abatement assessments are provided to them weekly. Now, when the collections division begins their billing process, I wouldn't know because that's in the finance department. It's not in our department. We do not handle the billing aspect, but we do refer that information to them. Now, we have undergone some changes in that process, in our process, especially reviewing older cases, and to be sure that we are giving information to the collections division timely, because in the past, there was a breakdown in that system. Not since December of 2019, but prior, there had been a breakdown in that system. Now, I can't say that there's not a breakdown in your particular case because there's not one been brought to my attention as a manager for me to review. But I do see from the documentation that I do have on the screen here, it does show the constant communication that Inspector LaRue has been having with you. And it looks like it's the updates that the inspector is required to continue following up in order to gain compliance. And I do see that the commission did uphold your property for demolition on January the 9th of 2020, which authorizes the city to demolish. And it does look like what I heard from Inspector LaRue is that some concerns around March on the contact where it looks like Mr. LaRue spoke with you, Ms. Counsel, is that y'all were concerned as to whether or not the city was going to step forward and effectuate the ordinance by knocking it down ourselves and placing a lien on the property, or if y'all could have more time to do it. Now, when the original notice of violation was issued, which is what was on what I have on the screen here, I'm sorry, hold on, let me pull it. It's right here. This notice of civil penalty, when the inspector issues this notice of civil penalty, this penalty is live and it runs continuously because it says right here that this penalty is going to run until the property complies with the minimum housing code. Obviously, either complies because the structure is completely repaired or complies when demolition, because when it's demolished, the violations are effectuated and there's no more violation of the code. So in this notice, it does say that it's going to run forever until this condition is remedied. There is no additional notices that follow the notice of civil penalty. Once they issue notice and once the administrative staff has provided service, then this penalty is in effect. And our city council obviously knows this when they have this discussion, and they wanted to provide us with an out on how we can help you, the citizen. And that is where they've written into the ordinance, allowing the director of the neighborhood development department to reduce any penalties that occur, knowing that your penalties are accruing before they accrued at $75 a day. City council made a reduction, changed that ordinance to where they accrue $10 a day. But they wrote in there that a policy can be adopted by the neighborhood development department, which is its director, that allows for a reduction, and that policy allows for a reduction that cannot be reduced no less than $500. Now, one of the two things here that I mentioned earlier with this policy was in effect in exactly what's on this paper, except for number 4 and 5 at the time that I considered a reduction for your request. And 4 and 5, what this does, this helps good faith purchasers that come in and there's a penalty already accruing. For example, if your property is sold and the next person comes in, obviously they're inheriting a property with a penalty that is accruing, right? Because the penalty, once it's issued, it runs until compliance. What this does now is if there's an order to repair issued or adopted, or an order to demolish issued or adopted, it forgives in its entirety to zero 120 days if the owner, the new purchaser, gets the violations or demolishes the structure within this time frame. If they repair it within 120 days, 4 months, or if they demolish it within 180 days, 6 months, then it is forgiven to zero. That is for a good faith purchaser. So in your case,
Excuse
the
me,
civil
excuse me,
penalty,
Mr. Powell.
yeah.
Yeah, so you're reading that bit about if a purchaser, not Ms. Hux, not Mr. Hux or Ms. Counsel, if a third party comes in and wants to buy their property, right? Then they don't suffer any penalties. Is that what you're saying, right? Do I understand that?
That's correct. The
Of course,
good
this
faith,
doesn't apply to,
good faith.
this doesn't apply to them, but like if somehow they could have engineered that somebody else bought this property, then that $500 thing would have gone away for them?
Not for them, no. It would have gone away for the new purchaser.
Okay, so I just want to stick to the stuff that, since we're not in that scenario at all of outsiders, if we can just stick to their situation, right?
Yeah, so I'm providing evidence of the policy for your consideration, and I have to, because the other evidence form is not here. I'm just telling number 4 and number 5
Okay.
is not on
So
the
you got to
previous.
finish reading the whole thing. Okay, I understand that.
Yeah, I'm done with it. Any other questions?
The only
All right.
question, I'm sorry, the only question that I do, just what I would like to reiterate is I know that you're saying with the fees and everything accrued, and that, there was an issue with, I guess, correspondence or fees being sent out to individuals. And I have to truly believe that I had to have been one in that case, because if you are now sending things to collections on a monthly or a weekly basis, why was it that from January of 2020, or even before that, when you're saying that fees were assessed, why is it that I never received any type of fee or billing that I needed to pay any fee until February of 2021?
And I don't even know. I have a question for Attorney Baker. Attorney Baker, if we as a board feel that the city did not uphold their end of the bargain, what happens if we do not uphold it?
I'm not sure I understand your question. I think I think what you're asking me is if you feel that the city did not provide adequate notice of the accrual of the civil penalty. And I think that question goes back to Ms. Counsel. We've put the notice of civil penalty up. I've heard Ms. Counsel say she received that notice of civil penalty. So I think that answers that question, that she did receive appropriate notice of the civil penalty. And she's on notice that the civil penalty begins to accrue. So I think that
basically our hands. So basically, we really cannot. I guess the point of this appeal is something that we really can't do anything technically about, because
the point of the appeal is to make sure that the city has provided the proper notice of when the civil penalty begins, that the city staff has taken into consideration the invoices that would be applied to this property, and has done so correctly, and has done the math correctly.
Can I interject?
I'm sorry.
Can I interject?
Let me finish, please. So the question for the commission is, did the city send sufficient notice pursuant to our ordinance and policy? Based upon the evidence here, it appears that the city did send sufficient notice, that it was received. Then the next question is, have the penalties been correctly calculated based upon that notice? It appears that they have been. If not, I would suggest they between the dates of issuance and the dates of compliance, it appears the penalties are actually less than $10 a day for that period of time. But then the next question for the commission is, did the staff give the appropriate credit for the work applied to correct those violations cited? And here staff has said, yes, there was ample credit based upon the work that was corrected that would reduce these penalties pursuant to the policy to $500.
Now, what if we don't? What if we decide that we cannot properly vote and agree on this situation? We like to have it pushed to city council. Can we do that? Let's say we say, I just don't understand it. I don't see everything all the way it is. Everybody decides that they're just not going to vote on it. Can it be pushed? Can it be appealed to a higher body than ours?
Mr. Brown, my understanding is we can always make recommendations to city council.
Yeah.
And that ordinance would apply to decisions of this commission until it were changed by city council.
If I could, that the provision is the city's charter, that is state law. It may not be amended by city council. It has to be amended by the state legislature, should the city council want to ask the legislature to amend it. So it's not a decision for the city council.
Okay.
Understood. Going back to Mr. Brown, I think I share similar concerns that you do about people just not understanding the fine system. Is that basically about what you're saying?
I mean, candidly, to be honest, and I'll say it, make sure it's in the minutes. I find this rather interesting that we are dealing with this appeal and the records are just so exact. While we are going to probably look at other things and the records aren't that exact. And this is one of those cases where clearly they did what was requested. They did it during COVID. So we haven't, there's nothing in the state legislature, and this is something that hopefully the legislature is watching, that's going to amend. Second of all, most importantly, I think we're all kind of taciturn about it due to the fact that we're like, what are we listening here for? I feel like clearly the citizen didn't truly understand what's going on. I think the paperwork that the city has is leading it one way, and I think their understanding of it is leading another way. And you know, I would guess I would ask the council, what if we just want to postpone this case? What happens if we postpone it?
Well, we can always vote to continue.
Yeah, we sure can. I just want to know. I want to ask Mr. Baker, what happens if we postpone this case? There's obviously no civil penalties being accrued. What happens?
I'm not ignoring you. I'm thinking.
If we decide to postpone this case for another year, maybe 2 years, maybe 10 years.
I mean, other than a dereliction of responsibility, I'm not sure I can, but that would be the first.
Exactly. Other than being derelict in that, we would say, hey, we just like to think about this a little bit longer. Give us about 2 years to think about it.
Now, commissioners, one of the things that generally happens when you have a case exactly like this, the city attorney's office refuses the appeal, which in this case is exactly what would normally happen. Is if there is no standing for the appeal, meaning that there's no action for the commission to take. The reduction policy has been followed in compliance with the city ordinance. So there's no additional relief that could be awarded to to Ms. Council, because the full relief of $500 is it. She's still due $500 to the city. The collections division is still going to pursue collections. They will still go to small claims court to get a $500 money judgment against the property or against Ms. Council. They're going to still follow their processes because the city ordinance has been followed. So generally in this situation here, where what's normally would be coming to an appeal for the commission would be a person that has $10,000 in civil penalties that is assessed to them, and I only allowed $2,500 reduction, which means that would be an interpretation that I don't accept this receipt, but I accept that receipt. Then the commission would hear and say, hey, okay, you allowed only down to a $2,500 reduction, but the commission finds that these additional receipts should be accepted and should allow reduction all the way down to $500. That's the normal appeal process that should occur. But if full reduction has been made that is in compliance with the city ordinance and in compliance with the policy, technically there is no appeal. You can make a vote for technicality purposes for Ms. Council, but there's no relief that could be provided unless Mr. Baker identifies that relief.
I have a question.
My question
please.
is, why are we listening to this then? What are we doing? Why did this come before us?
Again, if I can, the purpose
I
of
have
the
a
appeal,
question.
if I could answer, Council Commissioner,
Let's go in order. have Mr. Baker answer Ms. Furman's question, and then we'll get to you right after that.
Thank you.
Purpose of the appeal is for the commission to hear the evidence as to whether or not the city properly notified the citizen of the accrual of the civil penalty. That is the notice of violation that has been presented and from what I heard was received. That's step one. Step two is, have the civil penalties been correctly calculated? It appears that they have been, and it appears that they're undercalculated, but that's to Ms. Council's benefit. Step three is, has the city staff properly applied the policy to provide a credit as that policy is stated on behalf of Ms. Council? And I think those are the questions for the commission to answer. And addressing Commissioner Brown's question, if you decided simply not to hear it, don't think you have that authority. You may continue cases based upon factual reasons, but you may not continue cases simply because you do not want to hear the case. You have a obligation and you've given an oath to hear these cases and to issue a decision on the case. So I think those are the questions
I
for
get,
you in this appeal.
let me,
And I think
let me
that's
just
what
ask
we
a
asked.
question then. From, but you said earlier that if the full amount of the policy has been met, then legal counsel would not allow an appeal to go through. So I'm just wondering why.
I didn't say that. I did not, counsel did not say that. I don't know that I have the authority not to allow an appeal to go through. The due process requires that the appeal be heard. The question at this point is, what are you hearing and what decisions do you have to make? And those are what I've just said, was the process correctly followed and is the credit properly being given? Those are the issues before you. What I don't think you have the authority to do is continue it indefinitely to the benefit of the property owner. I think you have the obligation to make a decision.
Mr.
My
Baker,
only comment to that would be that the policy that was stated up on the board, since I don't have my packet, was the policy that was given to us 27 minutes before the meeting and not the policy at the time of Ms. Counsel's letter.
I understand,
We
but
need to see that.
the change in the policy
Doesn't matter, doesn't matter. It has to be the time when Ms. Counsel got her letter. What was the policy at that date? That should be the evidence that we should be seeing.
And I think that was.
And the policy, was the policy the same then that we're listening to now? If it's a different policy, then there's something wrong with that.
I think the evidence that's been presented to you is that the only addition to the policy regards good faith purchasers. Otherwise, the policy, the evidence before you is that the policy is as stated, is the same policy that would apply to Ms. Counsel.
Here's my question. Was policy the same?
I've answered the question. And I think Troy's answered the
The
question.
homeowner has been trying to put in a comment or question. I think we should just jump to her to let her get her comment
Yeah,
out.
and I have
Okay.
something to say after she's finished, because I've been trying to say something as
Okay,
well.
okay, thank you. If I could just reiterate two things right now at this point. One, with as far as being sent, I guess when you were saying that we initially were sent about, you said the $200 fee, and that was adequate enough. But I feel that wasn't adequate enough just that one time. Again, with the breakdown, if I would have known before that, more that fees were being assessed, then maybe we would have tried to see what else we could have done. Number two, talking about what the policy is now and the changes that were made in the policy, how was it that there's two more bullet points that was presented that weren't on the original one, as far as for a I believe it was, what was it, that at some point that it could be reduced down to zero, where there would be no fee. How was that able to be put on this new policy? Because I do remember in our meeting that we had before, the gentleman that I believe was supposed to speak before me had the issue where he was a first-time purchaser And he came into some property where he didn't know that there were fees that were already owed. And he didn't feel that he should have to pay any additional, not even that $500 fee. So it's interesting to me how now there is a policy that is up there that is addressing what I believe was his issue beforehand, and he's no longer speaking today. He has been removed. So how did that come about? That if I'm thinking correctly from what I'm seeing, how did that come about that was actually something new that was put on there to where it can now be reduced down to 0 for certain situations?
Thank you, ma'am. And I want to give some of my comments for commission discussion. I have two main concerns. The one is over proper notice. I have concerns that it was not understood by the homeowner, not reasonably understood that there would be a base minimum of $500. So that seems to go towards the notice provision. The other thing on the memo that was issued to us for civil penalty reductions, it says penalties issued may be waived or reduced by the Director of Neighborhood Development Department or designee with a civil penalty waiver or reduction policy to be adapted by neighborhood development. So I read that to say the Director of Neighborhood Development cannot reduce below 500. But then the second part says modifications of penalties by the director, designee, or city attorney may be appealed to the commission in accordance with section 1149. So that seems to say, based on my reading, that the department is limited to reducing to 500, but someone can appeal that decision to the commission and we have larger authority. So I'd just be open to discussion on that.
I also read that, and now that you've brought that up, that does sound substantially different. There seems to be no finites there at all.
From the, what you're not reading is the charter provision that limits your authority to the authority of the compliance officer. And the compliance officer is subject to the policy. So the commission is subject to the policy. That is the position of the city attorney's office in advising city council.
So I just had a comment that I think can clarify some of the questions you had, Mr. Brown, earlier. I've been trying to talk for a while now. For one thing, as far as when we were trying to go through the city program, we had to drop out of that city program because of some issues we had with the financing we were going through to work the program. So that's why that fell out of that program. But as far as this situation here, this is where I feel the city of Greensboro dropped the ball. I'm not going to put this all on Mr. LaRue, but if you go to that letter, the letter that was received in December, his name is on that letter. Okay, so that's who we contacted. So if you get a bill and you're concerned with a bill, you contact the person on that letter. So what we're finding out a year later is that it's two separate entities for a bill, and he has nothing to do with it. And he's only the inspection. So why is the money on that letter if we're not supposed to deal with Mr. LaRue involving the money? So when we ask him specifically, if he tells us specifically that if we update him that we're good, what are we thinking about? We're thinking about the money that was on the letter. So the city of Greensboro dropped the ball. So I understand your calculations, Mr. Baker and Mr. Powell. I understand what you're saying about the reductions. I get all of that. But what I don't get is that it's just clear as mud. It's just clear as mud. The whole point of us appealing this is because we thought that when we contacted him and we said we were going to demolish this property, that stuff stops. They went out to the property long after that letter came out in December. They went to that property late in January to go out and look at the property the day of that hearing. So how is the property already condemned? Why are they going back out to the property? And again, the money is on the letter along with his name. So that's who we're talking about. And we're thinking it's one entity. So that's why this stuff is convoluted. And that's all I got to say.
Mr. Hux, if I ever get in trouble, I would like you to represent me in court. So what I'm hearing, Chairman Isaacoff, is that you're raising this issue about, what our commission can do. And city attorney is saying that we are pretty much constrained by a charter, which says we don't, but there seems to be a legitimate argument about that. I understand what the city's position is, but there seems to be a legitimate argument that we can make, or that you can make, Chairman Isaacoff, about where does the commission's power actually lie. Another point I want to raise is, and I appreciate Mr. Hux talking about Inspector LaRue, because in my time as being a commissioner, I've always seen that Inspector LaRue is very conscientious. He tries to help people out. And I certainly understand that there could be miscommunications and misunderstandings. And Mr. Hux has certainly pointed that out. Ms. Council has raised the issue that there seem to be these quote unquote two entities that they got to answer. And what I can just tell them is, from my perspective, is you got one city government and you guys are taxpayers. And so you're entitled to be able to deal with one entity, which is the city. And I'm very sorry that you got to go through this stuff. And I'm also I'm not really sure, Chairman Isaacoff, what we're supposed to do. Like you said, Vice Chair Brown has asked, what do we do? From my position as a commissioner, I'm thinking I can abstain, or I can vote no, or I can just say nothing. But from what Ms. Council and Mr. Hutz are saying, we have seen plenty of taxpayers come before us who are not compliant. They don't show up, or they don't have their ducks in a row, or they really don't seem to want to cooperate with the city. And here we have two folks coming before us. And from my impression is they're trying pretty hard. So I'm not blaming Inspector LaRue. I'm not saying that he's wrong or anything like that, because I know he's pretty conscientious about this stuff. But it seems like we got to have some more room here. And I don't have an answer, Peter or Quentin, as to what we're supposed to do.
So, and I share your concerns, and I think this could have been a good faith miscommunication. Mr. LaRue, I have the utmost respect for you, and I know you do a very diligent job. Somehow, on someone's part, something got lost in translation. My main concern on this one is the lack of notice. And that's one thing that staff and council have made clear that we need to consider is, was there proper notice? And when you have someone whose understanding is they're doing everything right, no penalties are accruing, and then they get hit with the $500, even with the reduction, which the reduction is great, that should happen. But my concern is if they understood that those penalties were accruing at the time the first 500 was accruing. So I'll put that out there for discussion.
I don't think the commission has the authority to determine that the notice is insufficient where the notice was clearly mailed and received and indicates that the penalties will be assessed. The question is, did the city send the notice? Did the city indicate that the penalties would be assessed? That appears to be yes, based upon Ms. Council's testimony.
But we also have testimony from the homeowner, and from Mr. LaRue, that there were verbal conversations where certain things may have been represented. And, you know, a homeowner has the right to rely on an agent of the city. So if there was confusion there, I think that that trumps any written policy.
It does not. As a matter of law, it does not. As a matter of policy, it does not. It simply doesn't. I don't know how else to respond to that other than to say it does not.
So in your case, then sufficient notice is just one notice. Is that correct?
Yes, ma'am. As a matter of law, that is
Okay.
sufficient notice. You have notice the penalties begin to accrue. It will accrue till compliance. That's the question before this commission. Was that notice provided? You've acknowledged that you received it, therefore it was.
And so was it the city's obligation to inform then when we contacted the city? Was the city supposed to inform us that, hey, even though you guys are in compliance with us, you're still accruing fees? Was it the city's obligation at that point to tell us that when we're verbally communicating with the city? Because that's where the ball was dropped.
You're not in compliance until the house was demolished. That is compliance. Mr. LaRue has explained that he told you the city would not take action so long as you continue to cooperate and make steps to have the house demolished or repaired.
Is it
But
the
you're not in
city's
compliance until the house is
responsibility to
demolished.
explain the monetary fines at that point?
The notice of civil penalty explained that penalties begin to run and they will continue to run until compliance is met.
So was it Mr. LaRue's responsibility to go over that penalty at that point when we contacted him?
No, sir. You received the notice of the penalty.
So we received
Y'all-
one
y'all are-
notice and we're supposed to just understand that.
I'm happy to answer your question if you let me speak. You received the notice. You're both clearly more than capable of reading that notice and understanding what it means. That is your responsibility to understand that the penalties will apply until compliance. And compliance in this case was demolition.
So
Okay.
we thought that compliance we thought compliance would have been in speaking with him and him letting us know that everything is fine as long as we keep him abreast. At no point did he say we're still accruing money. That's
He
my
doesn't-
that's
So
my
as a
issue.
That's him.
I think as a training issue, then at this point, just so there aren't any misunderstandings, is, just a quick thing to say, there are two different fees, just so this
there's-
doesn't fall onto somebody else.
You can't hang that on a line in the letter from December when we're talking with you guys. You can't do that. That is not
So
right.
here's the thing, Mr. Huck. As the manager, I'd be the one to provide that training, and I'll definitely, be sure that inspectors are aware. But there's a couple different sides of that coin as well. One, every interaction that follows the notice, it would be improper or inappropriate for the inspector to constantly remind the person of the actions that could be taken from any enforcement action letter. For example, your order to repair, the very first letter that was issued in the very beginning, has verbiage in it that says a penalty could result for failing to comply with that order. So that is in that letter, in that verbiage in 2016. Now, they never issued a penalty because the city ordinance allows the inspector not to issue a penalty if the case is being considered for rehab. If you submit an application, if it is approved in process or in construction, we will not issue a penalty and we will not condemn the structure. And the notes that I had up on the screen earlier proves that. So when I looked at it as a manager and while we're sitting here with the case, and that's why I exposed it, so everyone can see it, it does look proper. Now, it does look like it was under consideration by rehab probably far too long, because it was for the entire year of 2017 and the entire year of 2018. That process is generally a 90-day period to make that decision and to get a house into the program. But from what you said earlier, it does certainly sound like y'all had some circumstances where you really couldn't pursue that program or so at that time. But if the inspector constantly every month reminded you, say, hey, do you remember that you're not moving forward with this? Do you remember the first order I gave you? It's a $200 penalty. If you don't move forward, that's what you're going to get. And then the next month, when the person comes back, you're not doing anything. Hey, do you remember the first one? So the inspector's not going to do that. It's gaining compliance is a partnership. It's a partner between that inspector and that property owner. They're going to work with you. As long as you're communicating and working, what more than likely Mr. LaRue is referring to, and he can speak up if I'm incorrect, is that after an ordinance is adopted in January by this housing commission, to where this housing commission told the city, yes, you have our authority to demolish this structure and to place a lien on the property. That's the ordinance that was adopted in January. If he's telling you that the city is not going to move forward and knock down that structure, which that is me then. If the city is going to knock down the structure, it's no longer Inspector LaRue. It's going to be assigned to a senior inspector, and then the manager and a supervisor is going to be involved from that point forward, just so that the inspectors can continue their primary focus, their primary job. But he can't tell you once he issues a civil penalty, unless you ask the question. If you ask the question, all right, hey, we're moving forward with this, we're going to knock this down, is that penalty still accruing? Unless you ask that question, he's not going to know that you want that answer. And he's not going to bring it up to say, hey, the notice I sent in December, I really meant that. And yes, that's still in play and you're still accruing a penalty. That's not what an inspector is going to do.
Right.
And we can share that with the inspector, but I wouldn't want that relationship to go south because it is
See,
a
that's where I'm
partnership.
saying that's what I'm saying on the
But
letter.
that's the part that I do understand.
Hold on, Jeanette, let me finish. His name is on the letter, and the $200 name is on a letter. So that's why when we're talking to Mr. LaRue, we think we're handling the money. I mean, do you understand what I'm saying?
I do.
We think
Yes, and
we're
he's
handling the money situation because
Yeah.
we're talking to the person's name that's on the same letter.
Right.
Yeah,
And as well, just to reiterate, we understand that, and it wasn't that we were asking for Mr. LaRue to constantly say, this fee is due, this fee is due. That wasn't it at all. We were just talking about the original time when we when we talked. If that very first time that it was just said, and like I said before, that could just be a training, just the very first time. Just so you understand, these are the fees that are still being accrued, and this is the other part of it. It would have taken me one time for him to say that the initial time, and then we would have known. It's not something that we wanted him to say, if he said it constantly. It was just the one time. But of course, as you can see, is that it was just a miscommunication, not something was lost in translation. But that's that point. The other point that I would like to find out is how do I need to move forward to get something put on the ballot or the agenda? I'm not sure how all that works, because like I said, the gentleman before that had an issue, he was able to get his reduced down to 0 and something be put on there. I think it was bullet 4 and 5. How does that work in my situation? How do I get something on there, to where maybe this can be reduced down to 0 as well? How does that work?
Ms. Counsel, if I can address that, please. The policy was amended so that folks who buy properties, if they bring the property into compliance within a certain period of time, if it's an order to repair and they repair the property within 120 days, then those penalties never begin to accrue against that good faith purchaser. They have 120 days to bring the property into compliance for repair. They have 180 days to bring a property into compliance if it is an order to demolish. That is to encourage folks to invest in properties and to remediate properties. For folks that own the property that have not repaired the property in a sufficient period of time such that civil penalties begin to accrue, we will give the policy gives those folks a credit, but down to a $500 minimum. I understand your question disagrees with the policy, but that is the policy. Until such time that the policy is amended to bring it down to 0, that is where the policy currently stands. We are encouraging folks to buy and remediate properties, and the penalties do not begin to accrue against those folks as long as they meet those time constraints. Had you sold your property with the penalty still accruing, and had you not demolished the property, but your good faith purchaser had demolished the property within 180 days, the full amount of the penalties would be standing against you without any credit for you, and your purchaser would have never been penalized because they would have met the terms of the policy, and they would have demolished the property within 180 days. So the penalties would never have begun to run, but you would still be facing the full amount of penalties because you would have no invoices to offset those penalties. You would have no credit.
So
Mr.
what it
Baker-
sounds like to me is that it's
Hold on.
encouraging those that,
Let me finish my thought.
okay, I
Let me
thought you were
please.
done. Go ahead.
I'm sorry. No, I'm sorry.
Baker,
I apologize. What I want to avoid is arguing about the policy, because the wisdom of the policy is subject to, in this case, delegated to the neighborhood development director, who has met with, I think, a couple of council members, but also with the city manager's office, and revised this policy. The only revisions applied to good faith purchasers. No revision of the policy applied to your case. The policy as it stands for your case has always been the same policy. So that wisdom, whether agreed with or not, and no disrespect, Ms. Councilman, at least to you or to Mr. Hucks, I understand y'all may not agree with the wisdom of that policy, but that has been delegated to the director of the neighborhood development department, and that is the decision that has been made. This commission is not going to, doesn't have the authority to tell the neighborhood development director what to do regarding the policy or to usurp that policy. The policy stands as is, whether we agree with it or not. That is the city's policy on reducing civil penalties. Now I am through it. Please go ahead.
I don't know that it's so much of a policy argument or just a lack of execution of informing the taxpayer.
Well,
That's my whole thing. I'm not even arguing the policy. I understand the policy, and that's what I said about the calculations. I understand them perfectly. I have an issue with the execution of what we needed to know. And my question now is, because we spent an hour on this, my question now is there a body, if this body can't make a decision, is there another body, or is there somebody we can appeal this to? Because we shouldn't have to pay this $500.
Are we able to talk to the director to try to get something changed?
The director's not going to change the policy. The policy has been considered, and the director can reconsider the policy, but it's not going to happen at this hearing. And to answer Mr. Huck's question,
it's not a policy.
Let me answer Mr. Huck's question. Mr. Hucks, you asked the question, if the commission does not uphold your appeal, and if the $500 penalty stands, you do have the right to appeal the case to the Superior Court of Guilford County.
Mr. Baker, how was the December 12th, 2019 letter sent? Do you have that in your file?
I would defer to Troy for the factual, to provide that evidence.
I'll pull that up. And also, Mr. Chairman, while I look for that, Assistant City Manager Kimberly Fowle has raised her hand. If you would recognize her, please.
Yes, please.
Thank you all so much. And thank you, Mr. Chair. So what I wanted to say was, I know that our policy stands as it is, but I am mindful of the concerns that have been raised by Ms. Council and Mr. Huck? Sorry. But I do want to say, feel free to reach out to the city manager's office. Again, my name is Kimberly Sowell. I am open to having the conversation with you. I hear your concerns. And so while we don't have an avenue for you to appeal to a particular body, you still can share your concerns with us formally. I've heard you on this hearing, but I do want to give you the opportunity to formally address your concerns to the city manager's office.
Thank you.
Thank you, ma'am. So jumping back, I believe, Ms. Council, were you making a comment? I think we were jumping back to you.
No, I think I finished that. I was just, again, I did finish what I had to say, just in reference to wanting to know if we could even speak with the director about our particular situation to see if something, something could be done in reference to our particular situation, or something different written in the ordinance just to apply to situations. So that was my only question.
And the last thing I wanted to check with Troy was that initial civil penalty letter with the 200 plus $10 a day. How was that sent to Miss Council?
First class and certified mail by policy.
Okay. So, commission members, I think you all understand the issues going on here. I just have concerns that the fines were understood by these homeowners. It sounds like there was confusion on that. I don't know what my motion or vote would be at this point, but I'll open it for discussion.
It sounds like we don't really have any choices because we have no authority. So in the spirit of the Criminal Reform Act of 1990 that set in place all the rules that the judges couldn't have any leeway with, I don't think we have any choices but to uphold.
I did have a couple of questions here. I think my first question was for City Attorney Baker. I know that we kind of talked about and brought this up earlier with the Ordinance 1149 that makes it seem like we have the authority to appeal on behalf of the homeowner, but the statute says that we don't. I guess what I was trying to figure out, if you could maybe better explain for me, why is it that in one part it makes it seem like we have the authority, but in another part it makes it seem like we don't? So could you give me examples of how we can actually execute 1149 versus the ones that we can't?
So 1149 is an ordinance that's issued by City Council. The charter, the city charter, is issued by the state legislature. The City Council doesn't have the authority to issue the state charter. The charter, section 5.74, and I'm clicking through. Let me find the specific provision. Regarding the Housing Commission, regarding appeals, if you look at 1149, there's the section that begins, the commission shall fix a reasonable time for hearing. The charter 5.74D says the commission may reverse or affirm wholly or partly, or may modify the decision appealed from, and may make such decision and order as in its opinion ought to be made in the matter. And to that end, it shall have all the powers of the compliance officer. What that means is you have all the authority of the compliance officer, who is subject to the policy issued by the ordinance or delegated by the ordinance to the neighborhood development director. So you are limited to the authority of the compliance officer. What can the compliance officer do? The compliance officer can determine that the notice was not properly sent. The compliance officer can determine that the penalties were not correctly calculated, and the compliance officer can determine whether or not the credit was correctly applied. Those are the things that you can determine in this case. And I think the evidence.
But department policies aren't something that's voted on by the public or by elected or appointed officials, right?
Policy? No, it is not. Policy is determined usually by the council. In this case, the ordinance delegates this policy to the director of neighborhood development to issue that policy. And because I was involved in some of those conversations, I know that Ms. Blue discussed this policy with a couple of council members as well as the city manager's office to revise it for good faith purchasers. But the provision of not allowing a reduction below $500 as long as I know, has been the longstanding policy and has not been changed. Mr. Scott, did that answer your question, comparing the ordinance to the charter?
Yes, I mean, it did answer the question. I guess a follow-up to that, it might be more maybe directed towards Troy, possibly, but I know we've had this conversation since I've been on the commission, I think a couple of times, of possibly the homeowners not understanding exactly what's being sent to them. And I know we've had discussions, I believe, before about maybe some revisions to the letter. I don't know if we need if this is a motion that we maybe can do here as a commission, to make, but is there a way that, because clearly, it seems like these, homeowners admittedly received the letter, but no offense to Mr. LaRue at all, but possibly through the conversations that they had with Mr. LaRue, also seems like it may have contradicted the letter. So in those situations where they feel like they may have gotten one answer from a city entity, but obviously they did get the letter that says something different, is there a way that we can revise the letter to, better spell out that, maybe where it's just in spite of conversations with other city employees, this letter supersedes that, or something in there that would inform, the homeowner that, regardless of the conversations you may have, this is the structure that makes it a little bit more clear for them. I'm not sure exactly how we would word it, but it seems like this case is clearly about miscommunication.
One of the things.
May I suggest that and I think it's a great question, Commissioner Scott. May I suggest that we table that question until the end of our meeting where you have additional comments? But let's focus on this hearing and try and get a resolution to this hearing before we go into what we could do down the road. And no disrespect, I just want to wrap this hearing up but let's definitely have that conversation at the end of the meeting.
Attorney Baker, if I may, I can kind of wrap it up in a way and answer council's question as well. The civil penalty and the condemnation notice that are issued concurrently are not the only mention of the civil penalties and potential fines going forward with the property. In speaking for myself solely, when I meet with someone for a hearing, which is that initial notification we send out after the initial inspection has taken place, I make it a good practice to delineate what is going to happen going forward with our process at that time, following with the order to repair. And if they do not comply with the order to repair or do not get an extension on that order, that then the civil penalties would start accruing at that time. So that, and as well as the order to repair itself, mentioning the civil penalties, I think does a good job, and it still falls upon us, I think, as the inspectors and city staff to communicate that thoroughly to any resident or owners involved with the property. In this particular case, I did not have that conversation with the owners of the property because I was not involved with the property until well after that order to repair had been issued. But in speaking with and training with other staff members, I implore you that is something that is done at the time of the hearing and with the subsequent order to repair being issued following that.
Commissioners, I'm going to make a motion and I'd like to have some discussion on it, and I'm open to revising it. I see two issues here. The first is one of statutory interpretation. I'm looking at the local ordinances right now and at the Greensboro Charter. I'm specifically looking at section 11-42, subsection B, which lays out the penalties of $200 and then $10 a day is what can be assessed. The assessment of civil penalties herein is not intended to be an exercise of powers delegated to other agencies, but the inspector shall not assess a civil penalty until the person alleged to be in violation has been notified of the violation by registered or certified mail or other reasonable means. The collection of a penalty pursuant to this shall not foreclose further proceedings. And then the important part I see is modification of penalties by the director, the designee, or the city attorney may be appealed to the commission in accordance with 11-49, which lays out our general appeals procedures. So frankly, and Mr. Baker, I just have to say I respectfully disagree with your interpretation of the ordinances. I understand the wording is ambiguous, but I see it as the inspector is limited to the $210 a day, subject to reduction according to policy, but that the statutes say that can be appealed to the commission. The other issue, so that's issue one, is one of statutory interpretation. The second issue I have is about proper notice. There has been testimony that they had conversations saying fines weren't being accrued. If that's the case, I have concerns that they were on actual notice of these civil penalties. So those are the two issues I have that I vote to not uphold and to waive the 500, but I'll open it for discussion.
If
I'll
I
second
could
that motion.
Can I interject, please? Mr. Ascoff, I'm not sure you're in a position to give the city legal advice, as the city attorney's office by statute represents the city.
I mean,
I
I'm just
understand.
reading the word, I'm reading the words of the ordinance.
I would encourage you to let the city attorney's office interpret the ordinance as well as the charter provision that contains language not in the ordinance. And the charter, of course, being issued by the state legislature, not the city council.
And I've read it and I don't see it prohibiting us waiving the remaining $500.
Yeah, he does. And I'm sorry you disagree with the city attorney's office, but that is our job to advise the city council and to advise the city and to interpret the ordinances and state law for the commission.
Mr. Chairman, I think we can understand that we have been advised by city council and we can still move on.
Yes, we have.
Properly advised us.
Appreciate it. I'm going to second the chair's motion. I guess we're ready to call for a question.
What was the motion, please?
That we do not uphold and that we waive the $500. I guess we're ready for the question, Peter, whenever you're ready.
Is there any further discussion?
I just want to say that I believe our charter does support this decision.
Thank you.
I believe that Chairman Isaacoff has that at the very least raised a legitimate concern that maybe should be resolved at another place. So I am in support of the motion.
Any further discussion? Seeing none, we'll call the question.
Chair Isaacoff,
Yes.
Co-chair, or excuse me, Vice Chair Brown,
Yes.
Commissioner Waddell, Commissioner Waddell. She may be muted. Commissioner Scott,
Yes.
Commissioner Biggerstaff,
Yes.
Commissioner Furman,
Yes.
Commissioner Young.
Yes.
Oh, I'm sorry, yes. Commissioner Waddell, is she there?
I don't see Commissioner Waddell in the room any longer.
Very good.
Um,
Thank you.
Taking into account all the votes of commissioners present, that passes unanimously. So Ms. Council, as of right now, your $500 penalty has been waived by the commission. There may be further proceedings and just keep an eye out for anything you might get in.
Okay.
Best of luck, ma'am. I wish you the best.
If I
Okay.
could, I'm going to interject to say that, Ms. Council, I'm not sure the issue is resolved. I really don't know the commission has the authority to make the decision they just made. And we can pursue that either with the city council or with the Superior Court. what I want to say to you is I don't think this issue is resolved. I don't think this is a valid decision. But hopefully we can resolve that in the very near future. And I'm sorry you had to appreciate your time and your participation in this process.
Thank you.
Yes,
I
ma'am.
just wanted to say I appreciate you guys' time today. I know this is not like a huge issue for you guys, but I appreciate the time, and you guys are really smart.
Thank you, and thank you for raising the issue.
Thank you.
All right, so that vote has concluded. Best of luck to you both, and we will move on. Well, actually, we usually take a maybe 5 or 10 minute break around this time. Would any commission members be in favor of a 5 to 10 minute recess?
Yes.
That's fine.
All in favor, we'll just do a voice vote. Aye.
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 Okay, we'll be in roughly till about 3:30. We'll be in recess.
Okay.
Thank you, everyone. Hello?
Yes, Mr. Chairman, 236, are you ready?
Yes, sir. Are all the commission members back?
I saw Commissioner Biggerstaff's video earlier, but it looks like it's not on. And Ms. Decker, court reporter, are you good?
Yes, I'm with you. Thank you.
Yes, so we're ready, Mr. Chair.
Thank you. So we'll call this meeting back to order. The next case on the agenda is 820 Roberson Comer, or I take that back, 4331 Rehoboth Church Road.
Mr. Chairman, Brian Crawford, the attorney for the folks that live at that property, let me know this week that his clients were unable to consent to a virtual meeting. They simply don't have the technological ability to join. So he asked, without their consent, it's not even asked to continue it. We can't hear the case while we're virtual without their consent. Mr. Crawford, are you on?
I do not see his name, no.
Ms. Harris, Eunice Harris?
No.
I told Mr. Crawford without consent, there'd be no point in appearing, but that I would relay this to the commission. So I will tell you that we are told that the folks are very close to complete compliance or to compliance. And so hopefully by the time this comes back on, hopefully it won't come back on, they'll be in compliance and we'll just be able to remove it as being in compliance. But in either case, nothing to be heard today.
All right, so we'll take that off our docket. And next we have 1128 West Ridge Road.
Mr. Chairman, this is a case that the tenant was appealing the inspector's decision, 48-hour decision of condemnation because of no power. However, that tenant was evicted by the magistrate through a court eviction. We have verified the writ, and we've heard no more from this tenant. We believe that he no longer, as a tenant, no longer has standing, and that would be for the city attorney's office to make that determination. But without him present and knowing that he's been evicted, we believe it would be proper to withdraw that appeal, or based on y'all's decision to accept a withdrawal on that information.
Actually, if I could, if he's not here, if he's not appeared, we do have a writ of possession of real property giving the property owner the property back. It was not served because the writ indicates that the sheriff was told from the property owner that his stuff's already been moved out, the locks have been changed, he's no longer there. But just to clarify for the record, I would just ask that the commission vote to deny his appeal for his failure to appear. Well, I take that back because we're in virtual. We'd have to have his consent. Without him here, we'll have to take it off. I apologize.
Okay, so that is coming off the docket at the city's move.
Yeah.
All right, so we'll remove that one from the docket. Moving on. We have the Maywood Street matter was taken off the docket. And then we have requesting motions to rescind ordinances as a result of compliance. I'll just read all the addresses. 3902 Farrell Drive, 822A Holt Avenue, 2407 Pineview Drive, 613 Holt Avenue, 1014A and B Logan Street, 2205 Birdie Street, 909 Cranbrook Street, and 4123 Lawndale Drive. Are there any motions from commissioners on those properties?
Make a motion to rescind the ordinances for all the said properties.
And I'll second that. And I'll call the question.
Chairperson Isikoff,
Yes.
Vice Chair Brown,
Yes.
Commissioner Scott,
Yes.
Commissioner Biggerstaff,
Yes.
Commissioner Furman,
Yes.
Commissioner Young.
Yeah, yes.
Did Commissioner Waddell return to the meeting?
No, sir.
Very good. That would then pass 6-0.
Thank you. So that passes unanimously. That concludes our cases for the day. Just to make sure, are there any that I missed from city staff or anyone still left in the audience?
No, there are no other cases on the calendar.
Seeing none, our last two items for discussion were first the approval of minutes and secondly, the Agapians and the role of the Housing Commission regarding the recent civil penalties. So
Chairman
we'll start
Isikoff?
with, yes.
Chairman Isikoff, if I may, I would like to ask the commission to let staff move the minutes approval to your October meeting. Go ahead, if you would, reflect here what those corrections need to be so that we can get with the court reporter, make those corrections, and then we're going to get those to you for proper review and adoption at the October meeting, if that is acceptable.
Wonderful, thank you. That would be, I would be in favor of that. Briefly, I believe it was Commissioner Furman and Commissioner Young that had edits to the minutes. Can you just state for the record what those edits were?
Okay, so I am asking that we change the sentence that says, Ms. Furman asked that staff provide a list of inspection fees, etc. To Ms. Furman had received through a public records request a list of the inspection fees that were issued from March to December 2020. And I asked for clarification of the wording of the response, and then also requested that we ask council to forgive the amount of the inspection fees from that time period. And I believe it got put into the motion that went along with a few other things. And I'm not sure I see that here either, but I did not go back and watch the video, so. I can't
Okay,
tell
and
you.
yes, so real briefly, all city staff is released from further of the meeting, except for my supervisors. So Commissioner Furman, one of the things we done is when we initially reviewed the minutes, we did notice on our own notes that we thought a discussion was missing. Because in our memorandum that we're working on to go to the city manager's office to ask the council questions that the commission asked us to have them asked, I put in there the statement that commission expressed that they would like to waive reinspection fees during the pandemic of year 2020. That's how I phrased it. However, Ms. Judy Decker is on here. We did ask her to review the recordings again. She did do so. She provided us with a revised set of minutes. I'm not certain that you have the revised set in which we have red markings of that information, because it was, when we got it back, that's the reason I'm asking to move it to October. But thank you for letting us know kind of what changes that we can make, and we'll make those and we'll get those back to y'all earlier. And if you do have a revision, if you'll just simply reply, don't reply all, so we don't have to have the open meeting or public meeting problem, just reply back to me. I'll get with the court reporter and we'll prepare the minutes the way that they can be properly adopted.
Thank you, Troy. So Ms. Furman, was there anything further that you wanted to address about the minutes?
No, that's probably, sounds like it'll take care of it.
And then Mr. Young, I think you also had some edits you wanted to make.
Yeah, that said, according to what Mr. Powell had said, I'm just gonna send that on via email, and that'll move things along today.
Perfect, thank you. So the last item on the agenda is Mr. Young's motion for discussion regarding the Agapian landlord business and the role of the Housing Commission. I'm guessing that is in relation to how fines are collected. Mr. Young, would you like just to state your thoughts?
Yeah, so thank you, Mr. Chairman. My concern, as I mentioned, is about the Agapian case and the role of, and specifically the role of our commission. I know there's a lot of other stuff that people might have read or heard about or talked about that might be about other issues, but I am particularly concerned just about how things seem to be affecting or might be affecting our commission. So for those who weren't aware of this stuff, just really quick, it's something like we read in the media recently that a settlement was reached way back in March between the city and the Agapian family about the original $680,000 of fines that they incurred over, I think it was many years. And then some of those fines included violations at the Summit Cone fire of May 2018. That was the fire that killed five Black refugee kids. So I read that the city settled for, and I think the public read that the city settled for $200,000 because of misplaced evidence. I think that was the reason that was given. So my first question really is, like, since this is now September, why wasn't the public informed of the settlement way back in March? But specific to the commission, we play a pretty important role, a part in the process of ensuring safe housing for all Greensboro residents. So apart from the public, why weren't we informed? And I guess I'm talking to you, Chairman Isaacoff and Vice Chair Brown, you know, because I want to defer to you guys. You might know more than I do about this. So, you know, this is, do you know anything? Can you answer that question as to why our commission wasn't informed?
So, and I'll tell you, Mr. Young, I found out the same way you did through the news and record. I'm not aware that the commission was contacted in any way about that settlement. My only contact with the Agapian family and their businesses has been through the hearings where we've, you know, had them before us. But I think,
yeah, go ahead.
I was going to say, I think what you're getting at is some sort of suggestion or request to city council.
You know, like, you know, before we make suggestions and stuff, I guess, you know, the questions are out there from me about this case in regards to the standing of the minimum housing. So, for example, you know, we're in a process where we vote to uphold or not uphold inspectors' reports. And we've all been told more than once how critical that is. It's a critical part of ensuring, you know, the safety of residents. And we hear cases like the Agapians in a quasi-judicial setting. So that's a really high standard, as we've all been told. And I just remember that we even swear an oath upon accepting our appointments from city council to uphold the laws and faithfully carry out our duties and so on and so on. So that's a pretty high standard. But, you know, should we be assured that this process works? Basically, if the city is going to go ahead and take that information and so on, the stuff that the inspectors have put together, the reports that we've upheld, what neighborhood development has done, and then they basically, for reasons that are not really super clear, but a $680,000 of fines winds up being $200,000. You know, I think our commission needs to know if that's where the work of neighborhood development, the work of inspectors like Inspector LaRue and Inspector Mark, I remember, who was at Summit Cone in 2018, taking down all these reports, seeing the raw sewage, seeing all the crap that people had to live through. If this is what the result is, I kind of think we need to know something about it. And I just want to know if the city has contacted you guys as chairpersons of our commission, letting us know, like, the process works. This is a good process. This is how we're going to ensure people are more safe, Mr. Chairman. So I can't really have any answers to that.
I have not received any communication from public officials about that case. I've just been reading the news like you have.
maybe, maybe somebody knows, like, at the very least, $200,000, does that go to the general fund or does that go to neighborhood development? I mean, I'd really want to know that. I don't know if you've heard anything, Vice Chair Brown or Chairman Isaacoff.
My understanding is, and staff, correct me if I'm wrong, but civil penalties go to the general fund.
So I'm not going to speak to the legal case because that is city attorney's office place to talk about any settlement. However, when civil penalties are collected, civil penalties will go against, or collections will process them against any reductions. So in your Agapian case, they are eligible for reductions, just as the case you heard earlier. So each of those apartments were allowed to be deducted all the way down to $500 with proof of receipt for work done to correct violations in the dwelling. So a reduction decision letter was made in those cases. So whenever a settlement occurs, the collections division will apply, or they advise that they applied settlement toward each of the bills in that way. So it does not come back to neighborhood development. I will assure you, it did not come back to my budget.
And Mr. Powell, since you raised that point, I'm not sure if I understood fully, and I appreciate your answer, but based upon what we just went through with Ms. Council and Mr. Hux, any chance you think that we're going to see the Agapians coming before us and asking everything to be reduced down to 500, or is this a legal case that's, well, I guess you can't really answer that maybe the legal settlement just throws all that kind of stuff out. But you haven't seen anything coming from the Agapians asking like they want to appeal and come to us about getting it down to 500, have you?
No, they couldn't.
Yeah,
they
that's good to
cannot.
know.
They cannot appeal to you. And Mr. Baker I don't know what he's allowed to share in cases where the city is involved in suits.
The city council settled the suit. There were some credits that were provided for repairs having been done by the Agapians. That would not have come before the commission. That was evidence that was considered as part of the lawsuit. But the city council considered a number of factors and decided to settle the lawsuit.
So Peter, like, again, like, maybe this is something that city attorney and Troy can answer, Mr. Baker and Mr. Powell can answer, but from the standpoint of, I guess, our commission, and we've already had a discussion about perceptions that we just voted on 7-0 versus, as we heard very clearly from city council, what the position of the city is. These differences here, but my question, keeps on revolving around if there was something about whatever evidence misplaced or whatever the media is reporting and whatever comes out, I don't know when, but if there's some sort of procedural problem that went on, shouldn't the commission know about that so that we can do better work? Was there a procedural problem that
not that involved? No, not that involved the commission. There was not.
But
and I'm not going to go into detail of what we discussed.
I understand you can't go into details. But my whole
no, there was.
Yeah, I appreciate that very much, Mr. Baker. But like, how come we weren't told that in like, I don't know, like in March? Like
because the commission
you guys are doing good. Commission, you're following your rules. You're doing good, and the process that you're upholding is a good one, and so on. Because
the issues involving the Agapian. Sorry, I thought you were done.
Yeah, between March and now, I think we all know, sitting on this commission, that we've been like pretty severely reviewed, if you want to use the polite terms, about what we're doing, how we're doing it, and it leads all the way up to today. So I think it's a fair question for me to just ask, are we doing something wrong? Did we contribute to getting the Agapians down to 200K? I mean, I feel really bad, and I'll just say this to the other commissioners not aware of this. Like, besides the other inspectors and Inspector Mark and Stan Wilson, who are out there in May in 2018, along with the city council members who were on site at Summit Cone. You know, we saw what was going on with the Summit Cone families. We saw it, I saw it before and after the fire. I saw families that were broken by this fire, and they'll never be reported in the news. They just had to up and leave because they could not stand what was going on. The trauma that was inflicted was horrendous. I was working with the young people, some of my student activists. They had organized the Summit Cone office and the community center, which was really crucial for coordinating services after that fire. And I was there when the inspectors were going around trying to do their thing and trying to really dutifully report all the freaking violations were at that place. So what puts a lot of doubt in my mind, Peter and Quentin, is like, how effective am I on this commission? Because I just looked at this up on the website, and I see that like my appointment's up next week. My appointment's up, and I don't know how that works. So my question is like, we're finding out, we the public, we the commissioners are finding out that the city got it down to 200K, notorious landlords, been here before, been before our commission. We don't know anything about why it was knocked down from 680K down to 200K. To me, the question is, having been there, seeing the families suffer, seeing how hardworking the inspectors were on that day, seeing some of the aftermath. So where exactly is the accountability? Where the heck is the accountability? Whatever case was resolved in March. It's September. It's only now that like we're finding out through the news media. And where's the accountability? Well, we know who pays. So that's the thing that really burns me up and really concerns me. My appointment ends next week. I've made mistakes, but I've been inspired by the fellow citizens who sit unpaid here. And I wanted to make sure Ms. Council and Mr. Hux knew that we were citizens as well. We're not paid to do this kind of stuff. I know you all work diligently on this thing, but we're not there to protect the city. When struggling homeowners come before us, many of them Black and people of color, that they want to see a fair process. And I respect our chairman and our vice chair for really striving to make sure that they have a fair hearing when they come before us. As we go into this thing, we hear about the arrival of Afghan refugees who are going to be resettled in this town. And I don't want to see that kind of stuff. I welcome the refugees. There's a gigantic housing problem going on in our city, a crisis. Where are they going to be put? I sure as hell hope they don't get put in places like Summit Cone or whatever else is after Summit Cone at this point, which is ripping off people and so on. It was an honor to be on this commission. If I was reappointed to this position, I honestly do not know if I would accept or not. I'd really have to be thinking hard about that one. So Chairman Isaacoff and Vice Chair Brown, I really appreciate you giving me this time to talk about this stuff. I know maybe you don't have the answers and everything, but I think it should be part of the record that says, you know, we were not informed about a very, very critical issue that's important in housing in this city. Thank you.
Thank you, Mr. Young, and thank you for serving on the commission so diligently over all these years. So I'm trying to think of what action steps could be taken, if any, regarding this concern about basically wanting more information about this settlement from 680 down to 200. Mr. Young, is that fair? This is basically we want to know what happened.
Yeah. You know, Peter, I guess, you know, I'm glad to hear Mr. Baker assure us that basically we didn't screw up. I mean, I guess that's kind of heartening, but we already heard from two taxpayers for a whole hour And I think what they were saying was legitimate. You know, they made a good case. I'm not saying, you know, because I cannot interpret all that legal stuff from what Mr. Baker's saying and the point that you're raising, Peter. But it seems to be a legitimate concern. They're raising certain issues and stuff. I sure hope our city is actually listening, because I think the citizens and the taxpayers who come before them are basically running a clinic about how the city could improve itself. And Mr. Powell, all respect to him, he started out talking to Ms. Council about how this is a partnership. But we've seen more than just a few interactions where we as commissioners, as citizens as well, are sitting there, and it sure doesn't look like a partnership to me. It looks like we're trying to get people. And if the city wants to be in the business of doing that, fine. If they want to sit there and read all these rules and regulations to them, which I think most of us, you know, would have a hard time reading. And God forbid, if we've got an Afghan person who's soon be an Afghan American one day, is hit with those same papers, because how the hell are they going to read it? And even if it's in translation, it's not going to make any sense whatsoever. So I just hope that the city you know, again, I'm not making it personal about Mr. Baker or Troy, you know, or the inspectors, but I do feel we have said many times over, these are areas where you could do better. We could do better as a city in this area, that area, that area. And sometimes it sinks in. I wish it would sink in faster. The other thing I think is like, you know, because we're not supposed to give advice, and I get that. You know, we're not supposed to give advice to anybody, fellow citizens coming before us. Okay, you know, surely in the case of Ms. Council, it is not giving her an advice to say, like, if you don't like what's going on, you do have a city rep. You have a council member who represents you. You can call them up anytime you want and say whatever the heck you want. And you can also go before whatever that Tuesday meeting thing. Because she was asking something about, like, can I, like, almost asking permission, can I talk to the city manager? And as far as I know, yeah, you can. And I don't think that's giving anybody advice. I think that's their right. And sometimes I think when people come before us, it's like we are giving them permission to do stuff that they have rights as residents, taxpayers, etc., just to go and do it. And maybe they can't complain like hell, or maybe they won't reach satisfaction from our commission. But I don't think I think it's okay to say, like, you know, you have rights here. City council meets on this day, or you know what, this is the, you know, go to the website and you can look up neighborhood development, who's in charge right now. I think that's Michelle Kennedy, you know, whatever. And that's not throwing anybody under the bus. These are either elected people or appointed people, and they're public record stuff. So as much as we go through the legal stuff and everything, telling this and that, and we hear about, you can't go over this, can't go over that, this is what the commission can do, can't do. I think we can also say to people, because we want them involved in city government, we want them to care about their place, their residents, and most of the folks who come before us do care. They're trying to keep their properties up. Mr. Brown has always been a big advocate for making sure that particularly people of color were not unduly dispossessed of their property, et cetera, et cetera, et cetera, with good cause, because we know that's been a historical pattern and so on. So I understand what Mr. Baker is saying. I respect that the law is the law and so on. But we also know the law can change, and it doesn't hurt even if the General Assembly made all these rules and all our hands are tied, to have certain information being passed up to our city council to let them know how residents, taxpayers, voters actually feel about some of this stuff. So I just made my big speech. Chairman Isaacoff, and now I'm going to just shut up because you know, like, we all got to go home.
Thank you, Mr. Young. And I just want to be clear, are you proposing any motion or anything like that, or is this just points you want discussed?
Was I just fuming, or was I making a motion? Let me think.
I just want to make sure we process your statements appropriately.
My motion would be something like, If the city expects this commission to do a good job, then the city has to do a better job itself in making sure that people understand their rights, the rules, the rights, policies, the regulations, all that kind of stuff. And the part that I just threw in about the minutes from whatever last time that Commissioner Furman was also talking about had to do with like whatever information we're giving them, it should be translatable, if not actually translated. And I know how difficult that is because we have 100 or so languages spoken in our area, in our city. But unless the city is going to try harder, we're going to continue to see issues like this, which I would say in the case of the last case we just heard, Ms. Council, Mr. Hux, was probably avoidable. So Peter, whatever that motion was, that was my motion.
Mr. Chairman, if I may.
Yes, Troy.
Okay. So Commissioner Young, one of the things that I believe I might speak on is just simply put, when I came here with Greensboro, my involvement in the Gapian case and the review of any records and any testimony that I had to provide in that case, I've not seen anything where the commission has done anything that harmed the case, and I've not seen anything in which an inspector has harmed the case. Everything seemed put together very well. So I reviewed that with the city attorney's office as well as watching that case go through. So just to speak for, especially for the supervisors on here too, we did look at the records. I think the inspector's done a great job in collecting evidence. I think what you have is you simply have the basic elements of a lawsuit. And I think you have two sides coming together to compromise in a lawsuit. And I think that's what you're looking at. And I certainly would not take anything from it as being that the commission has done anything less. And I wouldn't want the supervisors to think or believe that their inspectors have done anything less. I think both sides. I think everyone has put forward their best foot and put forward their best case, and our city attorney's office put forth their best to fight for our city. The other thing with that you had mentioned on partnerships. I strongly believe, and this is what our training is, this is what we talk about all the time, is to get our inspectors to partner with the residents, to partner with the property owners. And if you look at these agendas, there should be it should be very evident, that partnership, because y'all just today rescinded 8 cases. Y'all been rescinding 8 cases or more every single month for the last 2.5 years. What that means is the inspectors are gaining compliance in those cases. They're partnering with them. We have 2,150 active cases right now, which 989 of them are housing cases, and you've only heard one appeal. Since I've been here in the last 2 years, this is the only appeal case y'all heard, and there's no others in line to appeal. So like I said, you only have one. Now, it does not mean that one citizen is any lesser than any other. It is one case, and they do get their time and their chance in court to hear, and just simply to make sure that that staff is following their policies. And that's what, of course, that's what y'all's charge is to make sure that if they want to appeal, they have a right, and to see that we followed what was written. So that's there. But yes, a true partnership, absolutely. Now, another step in partnership, let's see, Commissioner Biggerstaff is on here, so she can attest to this, and I welcome this. I wanted to say it earlier when Commissioner Scott had suggested it. Commissioner Scott had talked about in some of these letters, are we able to provide more information that might be better understanding to the person reading it? I am working on a document that's going to be attached to each letter that gives more information than they're going to need. They're probably not going to read it because it's going to be a full sheet of information, but I welcome that feedback. If any of you want to reach out to me personally, I'll send you each of the enforcement letters, and you're welcome to provide that feedback. Commissioner Biggerstaff and one other person, it was a previous alternate commissioner, went back and forth with me because both of them were wonderful in writing, and they helped me to craft the courtesy letter that we send. The ordinance enforcement does not require a courtesy letter. We added that in because of the influx of cases where we get 120 to 130 complaints a week. The inspectors cannot get there quick enough. So we done a pilot and we dispatched a courtesy notice, and we were getting 60% compliance just with the letter. So that was helping us to get improved quality of life in the community faster. And that letter to start with, yeah, it was not written all that well, not after I looked at the revisions. But I really appreciate that partnership with Commissioner Biggerstaff and the alternate commissioner at that time that helps me with that. So yes, Commissioner Scott, if you're willing to do that, and if any other commissioners is willing to provide that feedback, I welcome it. That's not the letters and stuff. It's my decision. I have to go through. Those letters have not been revised since I've been employed in the last over 2 years. So if there's something wrong with it, let's look at it. Let's fix it. We don't have to look at it as a commission. We could do it one-on-one on the side. Let's do some revisions to it. I'll forward it to the director. Obviously director, but to legal. Legal has to review all of my legal letters to make sure that we're protected on all the legal steps. But yes, I am very adamant, Commissioner Young, about our partnership on the citizen level, the commission level, as well as all of our departments as we work together. And I believe that is our city manager's office direction, and we follow our city manager.
I appreciate your words, Mr. Powell. Can you say, I genuinely appreciate what you're saying. Can you say something about the online form? I noticed that the online form about complaints, to file a complaint, it's been simplified. I don't know when that happened, but there used to be more explanation saying something to the effect that it did not have to be just the renter who could file a complaint. It was pretty clearly stated in the online, and now it's just like, here's the complaint form. Can you say anything about the word? Has anything actually changed about who can file a complaint?
No, I've not changed any of that since I came to Greensboro. And as far as I know, it's not been changed unless when the MyGov implementation occurred October 14th of 2019, unless the call center had some sort of change on the web form that was actually there. But anybody can file a complaint.
So in the recent past, I mean, I think it existed. I don't know when the time frame would have been, for at least up to a year ago, where it said, and I'm going to be wrong about this, and you can correct me about it, but basically it's something like you can get five signatures, right, of persons who are concerned, right, to begin to initiate an inspection. Is that right? I mean,
yeah, so you're
that
referring.
stuff was written out.
Yes,
It's
so
not
you're
there
referring.
anymore, as far as I can see.
Okay, so you're referring to a petition. So that is also there available. A petition to inspect a residential structure in the city of Greensboro. A complaint, what happens, the difference between a complaint and a petition, if you complain saying, hey, I believe this structure has violations of the housing code, the inspector has a right to go to the property, view the structure from the public right of way. If they don't see more than 5 violations from the public right of way or adjacent properties, they can't take a further action, but they will walk up to the door, knock on the door, and ask if they could do a walkthrough with the person there. If they deny it, case is closed. Inspector cannot go any further by law. Now, if a petition is done in which 5 citizens signs that petition, that inspector is required to do an inspection, even use an administrative inspection warrant. So they'll look at it from the right of way. They'll go to the door and knock. If they're refused, they're going to go get an inspection warrant. Now, the reason they can't do that before, and they do that because of city ordinance. The reason they can't do that before is because in the other case is because they don't have probable cause.
Okay.
In the city ordinance, more than 5 is probable cause.
Right. If I can just interrupt, because I know you know those rules and regulations well, and I'm glad that you've got them at your fingertips. The point that I'm making comes back to, I think, some of the excuse me, concerns that I've seen, and when I talk about the city doing better. Going back to 2018, working with the Latino families who were out in Summit Cone, the Montagnard families, Southeast Asian refugee families who were still out there, Congolese, Sudanese, I think they were Syrian. There was one Black American family out there as well that people don't realize, but the 35 or so families, not a whole lot of them know the difference between a petition and a complaint. And I'm wondering if maybe you guys could look at that from the user perspective, because if it comes down to it, and like in the near future where some church in our area who's sponsoring an Afghan family, or some individuals, a business group or something, and they see that God help them, but that the family is living in the equivalent of a Summit Cone mess, and they want to like get it to the attention of the city, then if you can make it easy for them, that would be a big help. I understand the distinctions that you're making, and they're important ones, but I'm talking about the perspective of those who do not know anything about those differences. And if that wording and to make it quote unquote user friendly, right? Make it more user friendly so that people can access that. And I think the rest of it, plain English, et cetera, and all the other stuff, good stuff that you're doing to make those letters, those written letters, more understandable.
Is this where you're referring to here? What I've got on the screen, this is on the code compliance page for the housing code.
Okay.
It has initiating inspection, and it spells out what the process is as well. But right here, it says how it starts, and there's your petition, your link to your petition, and you can request an inspection. Is this what you were referring to?
I think so. I'm not going to try to squint my eyeballs in that, but if you've got that literature up there, again, my point being, if you're a lay person trying to help out an Afghan family or whoever, and you're trying to like make sure that the landlord's going to respond, it's kind of hard to navigate this stuff or to know the differences between that, as you said, petition and actual complaint. I also notice on the actual complaint form, when you click on it, it has at the very top that this is all public record, et cetera, et cetera. And my worry is going to be that if you have folks who are undocumented or a whole bunch of other people who are vulnerable, they may look at that warning that all this is public record, that is accessible, your identity can be revealed, that maybe they won't fill it out. So I know there's not an easy way around that, but I'm just making a note of concern about how maybe there's a way around it, and that the city could do a better job with that.
I can tell you right now, since I've been on the board, I've always thought it was unacceptable that people could anonymously file complaints. You can't do that in court. If you go to court, you have the right to see your accuser. We need to have the same thing there, because when you start putting a name and a face to things, I think that shows for a higher level of transparency and a higher level of accountability. I mean, if a person really has an issue, because, Troy, I know you haven't been here as long as Peter and I have been here, but he can remember where, we would see issues where neighbors were having disputes, where people were throwing bags of dog and cat feces over the fence. And then they would write a complaint. And then the inspector would have to go out there. And of course, there was no accountability. You didn't know who was writing anything. So I've always felt like that was something to do that we, honestly, to the rest of the commission, I don't even think we should even review a case if we don't know who wrote it, period. That's just my opinion. I think that if a person takes the time to write out a complaint, they can take the time to say, this is my name, this is where I live. And I feel like that should be given to the person that they are complaining against, so they know exactly who it is. It's only right, it's only fair.
Well, and a lot of times, to your point there, for the complaint, we have a duty. All the inspectors are under oath, just as a police officer is as well. If a citizen calls in, irregardless of whether they give their name or not give their name, we still have a duty to act, and that is to follow up. Once the inspector goes to the property, all they're doing is telling the inspector, hey, there's a code violation at this particular address. the inspector's going to go to that address. If they don't see it from the public right of way, they don't go any further. Unless they have any specifics to actually go onto that property and interrupt that citizen's time, they're not going to go any further. If a person has those great details, then they'll go as far as they can to reveal those details with the information. But a lot of times, even when we put it on our records online, we'll mark an internal note if it has the phone number and the name of the person that's actually complaining. Now, anybody that applies for a PERT request, they'll be able to see who that complainant is. But because we're transparent about everything we do, even the cases when there's things not done, you know, when we're not able to inspect properties in a timely manner, it's all online for the public to see, for that transparency and for that accountability. So if the neighbor calls and says, hey, the way my neighbor over here is keeping their property is diminishing the value of my property, can y'all do something about the 3-foot grass, the rodents, the snakes, and everything else? Please don't tell them my name. I don't want them to harass me, but this is affecting my property. You know, I'm a citizen here. I got a fair right to have these codes upheld. They have that right, and we have to protect them. So we do it that way. Now, if a person doesn't want anything on record, we don't document the name, because obviously if we write down a name and phone number, it is a public record. Even if we put it on a notepad in our office, it is a public record, and we have to reveal it with a public records request. So I don't see any path down the road that's going to lead us to not being able to, or to say, hey, if you don't give your name, we're not going to follow up. I don't see a path like that for public service.
Say this, if you have a form that's online, you have to say, hey, ma'am, sir, we need your name. This is public record. It's very simple. You can say it just like that. And if you have it on computer and someone can file it, you can make it so that the form won't go forward until you fill out all the necessary asterisk areas. Pretty simple.
Yeah, we get
It'll be
complaints.
all right.
We get complaints through the call center, over the telephone, calling directly in our office. People mail us letters. People do the web form. People send petitions, and we also they contact their council person, or they contact the city manager's office directly. We get referrals from government officials like the fire marshal or police department. So we're getting complaints in from all angles, and we cannot ignore any of them.
All I'm saying is, no one's saying ignore them. All I'm saying is that you can request who's writing. They say, I don't want to give my name. I don't want to give what it is. Be like, well, we cannot take it viably. That's no different to me than a prank call. If you call out a prank call to the police department, they say, what is your name? You're like, I ain't giving you a name. They know the difference between a prank call.
They gonna still send a police officer, even if you don't give the name. They're gonna still send them.
Sometimes they don't. It does. Yeah. Sometimes they do. Sometimes they don't. But in this case, I feel like you can basically say, hey, we need to know that. It's not. I mean, it's not a big deal. I don't understand why people be afraid to say what they feel. Now, if they're afraid that someone's going to harass them or they're going to have retribution, it's no different than if you had to do the same thing in a court case. It's no different.
So what I've got those notes made, and I'll bring that up when we meet with the new director as well as city attorney's office to see what our liabilities are as we're adjusting our policy for the inspectors. I'll add that to it.
I definitely agree with you, Mr. Young, and I'll keep this short so that way we're not on here too long, but I definitely agree with you. I think that for a long time, this department has had the stigma that they're going to get people, and I'm right there with you that I feel that government should work for the people. I've always believed that. It's not our job to work for government, it's government's job to work for us. That being the case, I do definitely commend and I appreciate you being on here. I hope you don't leave. I hope you stay a little longer. I think you get another term to serve, but I'm right there with him on that era of we definitely don't want to be, I mean, as you can see, and I think Troy and some of the inspectors can see, we don't want to be associated with a board that is about discipline and punishment. We're just here to punish you. That's not why we're here. That's not why I'm here, especially in these situations. I think Peter and I butted heads on certain things, but eventually we've started to come together and see like, well, we don't want to be rubber stamping certain things just because the verbiage says that. The reason we're here is because we're the human element. That's the whole point. If we see something that isn't right, it's our job to say it's not right. And because the rule books have been written to say something doesn't mean that it's right. I just want to make sure I've said this once and I'll say it again. it was law for my mama and my grandma to sit on the back of the bus. And my grandma and my mama's still alive. And she can remember being told it's the law to sit back there. So because someone wrote it down doesn't mean that it's okay. It just means that it's been written down. That's all that means. And what we have to do is be able to mirror through what we want our society to look like. And I do believe that every commissioner doesn't want to live in a society where a city can come and take somebody's house. No one wants to be in a society where they can legally write you out your own house that you've worked for. And apparently that has definitely affected people of color adversely more than any other race in the country. So I do stand with Andrew and with Peter. But you know, we want the city to be well, but we want to also be fair. And we also have to have a level of empathy. It's not just black and white. There's an empathetic part to what we do. And I think everybody on the board, whether we agree or not, can all agree to that we are not here to hurt people. We're here to help people. And we're not here to make the city's job any easier, because the city is nothing but a centralized government. We're just all working parts. But we do care about the natural homeowner. We don't want to have anybody out there homeless at all.
Thank you, Mr. Brown. Is there any further discussion?
And Mr. Chairman, when you finish that discussion, there was one thing that I had left. Y'all's annual training is scheduled in 2 weeks here in September. What topics would you like staff to pull together for that training?
That's a good question. Perhaps can we wrap up this discussion and then address that?
Absolutely, yeah. When that discussion is over, that's what I was asking for.
Okay, thank you. So anyways, moving back, Quentin and Andrew, I share your concerns of, I think the law should be accessible to everyone, and there should be plain language explanations of this is what this means for you in dollars and cents. That's my main concern, is folks don't understand what they're being fined for. So I agree with you on that. I guess my question is, having identified a problem, what solutions are we proposing?
Oh, boy, you're going to open up that door? Okay. Among other things, right?
I'd like to leave with future action steps.
What the city needs to do, and I hear what Vice Chair Brown is saying about the privacy stuff and everything. We have a very, very diverse city, and basically nobody that I know of, and I'm not even picking on the city now, but nobody likes to pay for interpreters. But if you want to see people better understand their city government, what they should and shouldn't be doing, when they should take out the trash, and when they're going to be held responsible for this and that, there's got to be more interpretation, more translation stuff. There's got to be a budget and a line item or something like that where this stuff can be paid for. It's not cheap, but it makes a world of difference. And even within our commission, we have Spanish speakers. One day we'll have even more languages in front of us, and we're quasi-judicial, so we have to be mindful. Everything needs to be basically interpreted by a qualified interpreter and all that kind of stuff. So people don't like to talk about it. It's a really minute kind of thing. If you're a native English speaker, it's a minute thing and it's a pain in the butt. But that's how it's going to make the city a whole lot better.
I agree with you, Andrew, and thank you for all your time. And I'm really sad if you do leave. I don't want you to leave our commission. I think you bring a really great perspective that a lot of times I don't think about. And so I appreciate when you do speak up. That said, I think just in general, and I don't think it's just a specific department of the city, but I think the city does have a communications challenge. Right now, apparently, they pick up my lawn clippings on a different day, and I have no idea what day that is, and I can't find it anywhere. And I speak pretty good English, and I can read pretty well. So the fact that I can't find it is concerning, and our city is based on being that open door and being a place that is a safe haven for refugees from all around the world. And it has been for a long time. And you would think we would be better at it by now. But that said, let's think about it and let's figure out how we can do it better. And I hope that we can make that happen.
Well, are we allowed to make a movement? This is all the stuff we got. I reckon we should make a motion to adjourn.
I think we have to talk about our class, right?
Oh, our class?
That's the thing. The chairman thought I was going to speak longer now that I'm an official politician.
Yep, you are. All
But I'll keep it brief.
So Troy, do we have to vote on the class today, or can you send around a Moodle page or something that we can figure out when we can do, or we need to figure that out
No,
right
y'all have already set your training. Your training is scheduled for September the 23rd. It's in 2 weeks. So it's already on your calendar. The only thing was we'll put topics based on what we're seeing in discussion about what we think that would benefit the commission. But I always ask, what in particular do you want me to make sure is involved in your training, and we'll pull that information together for you.
Okay. I think everybody has Troy's email. I don't see Peter anywhere. I guess he's not on. Does anybody see what happened to him?
It looks like he dropped off. He's not on here.
All right. On that note, I'd like to make a motion that we adjourn.
Are you gonna? So if I don't hear from anybody tomorrow, I'm gonna be setting up the agenda tomorrow so that staff can make preparations by next week.
That's fine. If you want to, if anybody has any special concerns, feel free to email and let Troy know what you want to see on there. I'm pretty much good with our standard training. We've been doing it for a while, so as long as if Carolyn has anything she wants to add, I'm sure she'll get on in there. Oh, Peter, I think Peter's back. But we were about to, I think we should make this motion. I guess we can wait for him to come right quick and then we can make a motion. Okay, so I'll go ahead on. There you go, Peter. You back? Peter. We can see your mouth moving, but we can't hear you. I think he's muted.
Yeah, I just sent him a request.
Hear me now?
Yeah, we got you now.
Sorry, I lost connection somehow, but I'm back up now.
Long story short, Troy is going to be setting up our training or whatever. If you have any specific issues or anything, I just told everybody they can just email them whether there's anything specific they want to see. Other than that, it'll be the standard rigmarole that we go through. Then we're going to make a motion to adjourn. But now that you're back, you can lead that. Go ahead.
Thank you. And just to bring a summary to the previous matters we were discussing regarding the Gapians and the discussion after that, it sounds like some issues have been raised. What I'd propose is to bring this up at the next meeting with the understanding that I think staff is going to get some information together for us. We can formulate our opinions better. That might be a better way to have this heard. What are your all's thoughts on that?
What was that request? You said staff will be getting what together? Now, if you're asking for details on the lawsuit settlement, that'll be deferred to the city attorney's office for them to release, because as you are probably aware, in most lawsuit settlements, some things can and some things cannot be shared. So that's why I can't speak on it, because I've not got privilege from the city attorney's office.
And I think that's what we're mainly referencing is, can you tell us anything that's publicly shareable about what happened, what the factors were, things like that.
If the question was the question, can I share anything at this moment?
No, saying next meeting.
I'd have to defer, honestly, I'd have to refer you to city council. I mean, this was settlement negotiations that occurred with city council in closed session. It is not public record. It's up to city council to release that information. But I can tell you it really wasn't a matter of mistakes. There were substantial reasons why the fines were reduced. And it had nothing to do with the Housing Commission, had nothing to do with staff. There weren't mistakes. There were legal defenses that were raised, that were considered, that justified the settlement.
And I guess that's what we'll let you understand is that thinking. Oh, hello?
Yes, we hear you.
Okay. So yeah, I think what we're looking for is just, I understand there were other factors, but we want to understand, since, we're the body that condemned those units, specifically the unit that caught fire and killed 5 kids, what were the reasons for that settlement? And then I know we're going to work on, and Andrew and Quentin, I direct this to you especially, ways in which notices can be made more accessible to people regardless of language capability, education, stuff like that. Maybe we move all that to the next meeting once people have had a chance to think out their thoughts more.
And if the commissioners certainly want to help with that education, we certainly welcome that. But just to let y'all know, the commission know, we do have a budgeted line item for interpreters, for interpretations, for translation. And we translate all of our notices into the spoken language of the property owner. It does cost a lot. It costs about $157 that I have to authorize for every single letter, but that's already been done. I just want to, just for the commissioners, just be assured that that you got a great city working for you. I've got hard staff that, that work in, day out, and there's certainly one of my philosophies, as well as leadership following, is that we enforce the ordinance with compassion and empathy. That is very important to us, and it's very important to my leadership philosophy.
I appreciate that, Troy, and I want to thank you again for everything you all do. I know a lot of this seems like, critiques, but y'all are doing an awesome job, and we're just thinking through ways to, make it even better. But I just want to commend you and your department for everything y'all have done, especially in the last year or two. It's really ramped up. Are there any further discussion points to be made? If not, I believe there was a motion to adjourn. Mr. Brown, did you make a motion to adjourn?
He did, and I'll second it.
I don't see Mr. Brown on here anymore.
I'll make the motion then. Ms. Furman, if you're okay with seconding that.
That would be great.
All right, we'll call the question.
Chair Isikoff,
Yes.
Vice Chair Brown, Commissioner Scott,
Yes.
Commissioner Biggerstaff,
Yes.
Commissioner Furman,
Yes.
Commissioner Young.
Yes.
Thank you, everyone. So with that unanimous vote, this meeting is now adjourned. Thank you all. Have a good day.
Thank you, everybody. Goodbye.